Yes.
Adjournments, list 1, B group matters, serial number 13. 13. 14 to 15. 14.
15. And for the petitioner, madam, on short adjournment.
Why do you want adjournment, sir?
Senior is inconvenienced for hearing.
See, it's a 2014 matter. What is this? You take a date.
Short adjournment, 1 week,
Take a date. On that day, no adjournment.
1 week adjournment.
The request of petitioner call on 1 week date.
9.
No adjournment on that day. It's a 2014 matter. Otherwise, I'm going to dismiss it. Yes.
16.
The request of petitioner on date.
12.
Hmm.
12 9. 13.
ರೀ 10 ದಿವಸ ಆಯ್ತಲ್ರಿ ಇವತ್ತು 2ನೇ ತಾರೀಕು ಆಯ್ತು 17th
17. Serial number 17 to 23.
Serial number 20, lots. A week's time, lots. First time inconvenience to them.
1 second. 21. The request of petitioner call after 2 weeks. 22 weeks. Yes.
Serial number 24 to 30.
Serial number 23, my lord.
Serial number 25, ma'am.
My lord, in this
23.
matter also, my lord, I need some instructions, my lord. Your lordship may have it after 10 days, my lord.
23 2 weeks.
A pleasure.
25, my lord.
24 25 2 weeks. ಏನ್ರಿ ಇದು ಆಯ್ತು 2 weeks.
31 to 33.
Serial number 32, my lord, 2 weeks time may be granted, my lord.
32 was a date given matter, no?
My lord, I have informed the other side.
Or Badrinath.
Okay, next week.
Informed the other side.
32 next week.
34 to 40.
Serial number 35, my lords. That I had moved the matter, my lords. I wanted for day after tomorrow for this reason, my lords. There is a same certificate by the PDA in favor of third person.
Right, not
I
that.
have to file the impeding application and
Four.
absence also. Day after tomorrow. Please.
4 9.
Oblige.
41 to 44.
44, my lord. Kindly have it on 11th or 12th. my lord. Senior is
2 weeks. 2 weeks. Right, 43 2 weeks. 43 on date ಕೊಡಿ. ಇದು ಅರ್ಧ ರಿಕ್ವೆಸ್ಟ್ ಅಂತ ಮಾಡ್ಕೋಬೇಕು ಮೇಡಮ್.
44 date.
43 18 9.
ರೆಸ್ಪಾಂಡೆಂಟ್ ಯಾರು ಕೇಳ್ತಾರೆ ಅದು.
43 18 9.
44 date may be given.
ರಿಮೂವ್ ಮಾಡ್ರಿ ತಗೊಂತೀವಿ. ಸುಮ್ನೆ ಹಾಕು ಡೇಟ್ ಕೊಟ್ಟಿ ನೀವು ಹ್ಯಾಂಡಲ್ ಮಾಡಲ್ಲ ಮ್ಯಾಟರ್ಸ್. Yes.
45 to 49.
Serial number 47, my lord. I am for the petitioner, my lord.
Bearing for respond number 4, your lordship.
Kindly place for 10 days time, my lord, because they are.
15.
All right, 2 weeks, 47.
2 weeks. 50.
Correct.
Serial number 1, list 1, Rajeshwar PN.
Respondent.
Huh?
Interim order, serial number 25.
25 ಅಲ್ಲಿ ಇಂಟ್ರಿ ಮಾಡಿದ್ರು ನೋಡ್ಬಿಟ್ಟು ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡಿ. ನೋಡ್ಬಿಟ್ಟು ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡಿ.
My lord, I'm filing memo for posting, my lord. It's a fresh matter.
With my lords kindly, serial number 15 was moved by the other side. My lords granted time and fixed the date as 9/9. May I request my lords to have it on 10th 9.
10 ಹಾಕಿ 15th.
I am grateful, my lords.
My lord, appearing for the petitioner in serial number 1, my lord.
Yes.
This petition is for seeking supplementary award for payment of compensation for Malki's structures and trees, my lord. It's also covered by judgment, my lord.
Yes, AGR 1 2 3
2 to 4, I take notice and also copy receipt.
2 to 4,
Sri
Sriram
Ramakrishna.
Krishna.
My lord, a date may be fixed for joints to be, my lord.
Call on date ಕೊಡಿ 2 ವಾರ ಬಿಟ್ಟು.
19/9, 19/9.
Objections 25.
Much obliged.
To Ketan Kumar.
Kindly pass over, madam. Kindly pass.
Pass over. What is this matter? ಕೊಡಿ ಒಂದು second.
Question, my lord. Kindly pass. I engage in service of senior counsel. Kindly pass.
5 ನಿಮಿಷ ನೋಡ್ತೀನಿ ಹಂಗೆ ನೋಟಿಸ್ ಆದ್ರೆ ಆಗಲಿ ಆಗುತ್ತಲ್ಲ.
Sorry.
Lords, widening of the national highway is undertaken. 3A1 notice is issued, notification is issued. Objections are filed under section 3C of the National Highways Act. Lords, may kindly see page 23. This is a 1,000-year-old temple. Lords will find this is the temple as it exists today. Page 23. Annexure D, page 23. This is actually the Car Street. Car Street, Ratibidi. This is the Car Street. Now, the lords may kindly take page number 28. This is where they are proposing to form the highway. Page 28.
ಟೆಂಪಲ್ ಏನ್ ಟಚ್ ಮಾಡ್ತಿಲ್ವಲ್ಲ.
ಅಲ್ಲ, ಆ ಟೆಂಪಲ್ ಅಂದ್ರೆ ಆ ಟೆಂಪಲ್ ಪ್ರಕಾರ ಪೂರ್ತಿ ಟೆಂಪಲ್ ಅದು. ಅದ್ರಲ್ಲೆಲ್ಲ ದೇವಸ್ಥಾನಗಳಿದೆ. ನಾನು ಐ ವಿಲ್ ಟೇಕ್ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ಸ್ ಟು ದೋಸ್ ಫೋಟೋಸ್. ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ಸ್ ಮೈ ಕೈಂಡ್ಲಿ ಸಿ ಪೇಜ್ 28. ಅದರಲ್ಲಿ what all is going, lords, we have mentioned that yellow marks, whatever we have mentioned, these are all parts of the temple only in that road portion. Now, what we said is, you are unnecessarily demolishing what is found at page numbers page 20, page number 30. ಇದೆಲ್ಲ ಹೋಗುತ್ತೆ. Page number 30. These things will go. So what we filed our objections was, instead of taking the road inside the temple, this is the entire thing is temple complex. Around the temple, there is a compounded area. Around the temple, there are other sub-temples which are there, which is part of the temple. For every kainkariams of the temple, every single temple is important. That is how the temple is designed. So what we suggested, kindly have a look at page 40. Notice this entire land, whatever we are now suggesting, is the temple land. ಆ ಟೆಂಪಲ್ ಮೇಲೆ ಹಿಂಗ್ ಹೋಗ್ತಿದಾರಲ್ಲ ರಾಜ್ಯ ಹೆದ್ದಾರಿ, ಅದು ಪೂರ್ತಿ ಊರೊಳಗೆ ಬರ್ತಾ ಇದಾರೆ. ಅದಕ್ಕೆ ನಾವ್ ಏನ್ ಹೇಳಿದ್ವಿ, ಪಾಯಿಂಟ್ A to point B, all these temple lands are there, which are vacant. And these are all temple lands only. Only one private land is there. Even this private land owner is willing to give it up, because this was a land which he got under the Land Reforms Act. So, from the temple, this was a temple property he got under the Land Reforms Act. He is willing to give up. We said, instead you do this. That's what the engineer says is that there is no scope for realignment. We will not consider your objections.
ಈಗ
Realignment ಪ್ರಶ್ನೆ ಬರೋದಿಲ್ಲ ಇದ್ರೊಳಗೆ. ಯಾಕೆ ಅಂದ್ರೆ point A to point B is there. Notes now, if your lordships were to see how the temple is going to be affected from page 28 and page number 40, as a matter of fact, there is a 90-degree curve which they are forming because of the temple. Kindly have a look at page 28 and page 40. ಇಲ್ಲಿ ಪೂರ್ತಿ ಒಂದು 90-degree curve ಕೊಡ್ತಾ ಇದ್ದಾರೆ. Technically, it is not a good road to be formed. That too, particularly national highway, should never have this kind of 90-degree curves. Now, what we are suggesting, is almost a straight road where the nature of curve is less than 40 degrees. So now the endorsement is issued without following the procedure under section 3C, saying that since there is no scope for realignment, we will not consider your objections. But lordships may kindly see the language employed under section 3C of the National Highways Act.
Okay, you want an interim order, or shall we give a date, ask them to
Your
come?
lordships may grant an interim order. They will also come. Ultimately, they considered, the engineers came, they inspected everything they considered. But what they say is, within the scope of our consideration, we don't have the powers to direct a realignment. So they say that whatever you are telling is technically feasible.
Union of India, yeah. Yeah, Union of India.
MN Kumar.
Kumar.
MN Kumar for R1. Two, three ಗೆ ಯಾರು ಶಿಲ್ಪಾ ಶಾನಾ?
Please.
ಅವ್ರಿಗೂ ಅವರೇ ತಗೋಬಹುದು. ಇವ್ರು ಅವರು
Shobhit Shetty, my lord.
ಶೋಭಿತ್ ಶೆಟ್ಟಿ.
ಆಯ್ತು. Shobhit and Shetty for respondent number 2 and 3.
4 and 5 is state.
4 and 5 is straight.
Ballarahalli state,
AGA.
PWD, national highway is not but
Respondents are directed not to precipitate the matter
only respond number 2.
in respect of petition schedule property till next date of hearing.
Please,
Huh?
I may be permitted take notice only for the respond number 2. Whereas this particular stretch is concerned, this is not with the respond number 2. Still it is under the control of PWD only. So even respond number 2 is not a necessary party. So I may permitted take notice only for respond number 2 for the chairman NHA.
So what about executive engineer National Highway
That
Division?
state only.
ಆಯ್ತು. 2 ಬಂದು ಶೋಭಿತ್ and Shetty. 3, 4, 5 ಬಂದ್ಬಿಟ್ಟು state.
State.
See, there is a threat of
Demolition of temple.
demolition of a temple. So they are suggesting an alternative route.
Yes.
Okay, which at least on the face of it looks feasible. So take that into consideration.
Yes.
ಅರ್ಥ ಆಯ್ತೇನ? See, ವಿನಾಕಾರಣ in fact you look at those things, page number copy ಇದೆಯನ್ರಿ ಕೊಡ್ರಿ ಅವ್ರಿಗೆ copy.
ಕೊಡ್ತೀನಿ ಅವ್ರಿಗೊಂದು ಕಾಪಿ.
Copy ಕೊಡಿ, let him have a look at it so that he will understand it. Come to page number 23 first.
23.
See, this is where the temple is situated.
Yes, my lord.
Okay, then come to 28.
I am aware of that place, my lord.
ನೀವು ಮಂಗಳೂರು ಕಡೆಯವರ ಅಲ್ವಾ?
I am aware of that place.
So you will be knowing it better. You will be knowing the sanctity also better, much better than any one of us over here. Come to page number 28. The proposed road.
20. Yes, my lord.
Okay. ಅದು ಊರ್ ಮೇಲೆ ಹೋಗೋದು, ಹಳ್ಳಿ ಮೇಲೆ ಹೋಗುತ್ತದು.
Yes, my lord.
ಆಯ್ತಾ? ಇವ್ರು ಪ್ರಪೋಸ್ ಮಾಡಿರೋದು ಪೇಜ್ ನಂಬರ್ 40. 40. What appears to make sense. I mean,
Yes, my lord.
we are not, we are nobody to pronounce on that. But on the face of it, 40 appears to make better sense. An ancient temple, just if you can save it, save it. And you know the importance of temples in your place. Modern day temples, yes, we understand.
Yes.
No need of any protection. Modern day places of worship.
Modern
Ancient
day
places of
temples come
worship.
up only to obstruct the roads.
ನೀವು ಹೈಕೋರ್ಟ್ ಆರ್ಡರ್ ಮಾಡಕ್ ಬಿಡಲ್ಲ, ವಿ ಆರ್ ಜಡ್ಜ್ಮೆಂಟ್ಸ್. ಇದು ಇಲ್ಲಿ ಪಕ್ಕದಲ್ಲಿ ಯಾವ್ದು ಬಿಲ್ಡಿಂಗ್ ಅದು?
KJ8.
ಹಾ,
KJ8.
KJD ಬಿಲ್ಡಿಂಗು ಆರ್ಡರ್ ಮಾಡಕ್ ಆಗ್ತಾ ಇಲ್ಲ. ನೀವು ಇಷ್ಟು ವರ್ಷ ಟೆಂಪಲ್ ಹೊಡೆದಾಕ್ತಿವಿ ರಾಜಾರೋಷವಾಗಿ ನೋಡಿ ಅದು.
Yes.
Don't precipitate the matter till next date of hearing.
Yes,
But
ultimately.
ask your officers to work on it, state also.
Please, ma'am.
It is in the control of.
Our
PWD.
engineers inspection ಮಾಡಿದಾಗ ಅವ್ರು ಹೇಳಿದ್ರು, what you are saying is feasible, but it is not within the scope of our responsibilities to permit a realignment.
So
That's
they
the
are
problem.
taking DPR.
ತರ್ಲೆ ಮಾಡೋದು ಬೇಡ. ಯಾರಾದ್ರೂ ತರ್ಲೆ ಆಫೀಸರ್ಸ್ ಇದ್ರೆ ಅಪ್ರೈಸ್ ದಮ್ ಪ್ರಾಪರ್ಲಿ.
They'll go by.
ಕೆಲವ್ರು ಬೇಕಂತ ತರಲೆ ಮಾಡ್ತಾರ ಸ್ಟೇಟ್.
Bismillah.
ಕೆಲವ್ರು ಬೇಕಂತ ತರಲೆ ಮಾಡ್ತಾರೆ. ಅದಕ್ಕೆ ಮಾಡೋದು ಬೇಡ ಅಷ್ಟೇ. They can save it, let them save it. Yes.
Grateful.
ಅದು ಡೇಟ್ ತಗೊಂಡ್ಬಿಡಿ ಬೆಟ್ರು. On that day there will be some pressure also if we give a date.
Understand.
20th one.
Call on 2 weeks ಬಿಟ್ಟು ಡೇಟ್ ತಗೊಳ್ಳಿ.
My lord, have it on 20th, my lord. Long date, my lord.
20th. The national highway has to happen.
Please, please, ma'am.
Let us not stall the happening of national highway, but
See,
do it in a manner
What will
that
possibility in, my lord?
yeah. So date is given because there will be some pressure on them to take proper
Yes.
instructions and
Please, please.
on 2-3 months only if they can just
Please.
come up with a proper plan,
Alignment.
alignment which satisfies everybody, I think everyone will be happy.
Please.
Anandramu.
Lord, 3 is concerned, my lord.
Swami.
This is pertaining to my lord. PRR 2 is concerned, my lord. This is a, my lord, meeting is going on, regarding, my lord, the government also, my lord, take some decision on that, my lord, on have it on, my lord.
In the first case, my lord, we are not related to the compensation.
Illa.
We are for the denotification, which is
Alla.
far away from our particular.
In respect
property
of, my
to
lord, the
this one, my lord.
denotification ಆಗಕ್ ಸಾಧ್ಯ
ಅವರೆಲ್ಲ ಒಟ್ಟಿಗೆ ಹೇಳ್ತಾರಂತೆ.
ಅಲ್ಲ denotification ಮಾಡಕ್ ಸಾಧ್ಯನೇ ಇಲ್ಲ, because, my lord, honorable apex court also given directions on that.
Kindly see, in
What
my
do you
particular
want to
survey
do with
number,
the-
they formed already road, my lord. Another survey number is far away. I produced the documents.
It's all right, so we'll hear it. ಯಾವಾಗ?
My lord, have it on 19th.
ಅಲ್ಲ ಬಹಳ ದೂರ ಆಗುತ್ತೆ.
ಇಲ್ಲ ಇಲ್ಲ
Now we
50
are
meeting,
suffering
my lord.
from 2014, my lord.
ನಮಗೆ out of 10 kilometers, 9 kilometers road we have formed,
my lord.
only 1 kilometer.
Because, my lord,
So
because
that thing,
on
ನಮಗೆ
fifth-
urgency ಇದೆ more than them.
on fifth, my lord, the cabinet meeting is going on regarding this issues concern, and we have placed before the meeting regarding, my lord, whether, my lord, fresh compensation ಕೊಡೋದಾ ಅಥವಾ ಹಳೆದ್ರಲ್ಲಿ ಕೊಡೋದು ಅನ್ನೋದು ಆಗ್ತಾ ಇದೆ, because Supreme Court has already given direction to implement the project. Now we can't, my lord, go the order of this honorable.
Two-
That date, my lord,
2014
we are fully ready, my lord. We'll come with, I mean, our objections, we are
That is,
compilation of the orders passed by the.
Yes, so
Honorable
the
Supreme
request of AG call on 20th date ಕೊಡ್ತೀನಿ.
this week only, my lord.
ರೀ ಇಷ್ಟ್ ದಿನಾನೇ ಮಾಡಿಲ್ಲ, ಮಾಡ್ತಾರೇನ್ರಿ ಅವರು?
ಅದು ಹೇಳ್ತಾನೆ
ಸುಮ್ನೆ
ಬರ್ಲಿ,
post ಆಗುತ್ತೆ,
December,
ಮತ್ತೆ adjournment ಆಗುತ್ತೆ.
since, my lord, since from December, the same.
ನೋಡ್ರಿ,
subject,
it
my
has state cabinet is under a paralysis,
ಅಲ್ಲ
right?
ಅಲ್ಲ ಸ್ವಾಮಿ, ಇದ್ರಲ್ಲಿ ಒಂದ್ ನಿಮಿಷ ತಾವು ಒಂದು ಹೇಳಿ,
They won't do anything.
1 second, my lord.
ಮೊನ್ನೆ ಮೂಡ ಅವ್ರನ್ನ ಆಫೀಸರ್ಸ್ ನ ಕರೆಸಿ ಉಗುದಿ ಮಾಡಿದಕ್ಕೆ ಏನೋ ಒಂಚೂರು ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಬಂತು.
ಅಲ್ಲ ಇದ್ರಲ್ಲಿ ನಾವ್ ಏನು ಮಾಡ್ತಾ ಇಲ್ಲ ಅಂತಿಲ್ಲ ಸ್ವಾಮಿ, ಮಾಡ್ತಾ ಇದೀವಿ. ಇಲ್ಲ ಇದ್ರಲ್ಲಿ ಆತರ ಏನಿಲ್ಲ, because we have implemented project, my lord, because and that is the reason, my lord, because one
Go irrespective of the political.
please and
turmoil
also
in the
give,
state.
please.
Okay.
ಅಲ್ಲ ಅದಕ್ಕೋಸ್ಕರನೇ ಮಾಡ್ತಾ ಇದೀವಿ.
Here,
ಒಂದ್ ನಿಮಿಷ.
tell your officers ನಿಮ್ಮ ದೈನಂದಿನ ಕ್ರಿಯೆಗಳು ಮಾಡ್ತಾರಲ್ವನಪ್ಪ ಅವರು.
PRR too, my lord, we are giving them 50% of the development.
The land.
Though, my lord, in other, in Kempegowda and even where in Bondoramaswamy, the Honorable Supreme Court said, it's a benevolent scheme where we were giving only 40%.
40%.
But in view of the urgency and for the formation of the road, here we are giving 50%. That is 100%, my lord, will be
Yes, done.
more beneficial than any award and whatever.
There is, in my case, there is no need of the my land, my lord. The unnecessarily suffering from 2014.
ಇವಾಗ ಇನ್ನೊಂದು 2-3 ತಿಂಗಳು ತಡ್ಕಳೆ, ನಮ್ ರೋಸ್ಟ್ರಲ್ಲಿ ಆಗ್ದಲೇ ಇರ್ಬೋದು ಇದು.
ಇಲ್ಲ ಹಂಗೇನಿಲ್ಲ ಸ್ವಾಮಿ, ತಾವು ಅದ್ರಲ್ಲಿ ಲೆಟ್ ದೆಮ್ ಫರ್ದರ್ ಹಿಯರಿಂಗ್ ಹಾಕೊಂಡ್ಬಿಡ್ತಾ, ಆತರ ಏನಿಲ್ಲ.
ಫರ್ದರ್ ಏನ್ ನಮ್ಗೆ ಬೇಕಾಗಿಲ್ಲ, ನಾನು ಹೇಳ್ತಿರೋದೇನಂದ್ರೆ ಟೈಮ್ ಫ್ರೇಮ್ ಹೇಳ್ತಾ ಇರೋದು.
ಕೋರ್ಟ್ ನಾಟ್ ಕಮ್ ಟು ದಟ್ ಕನ್ಕ್ಲೂಷನ್.
ರೋಸ್ಟರ್ ಅಥವಾ ಅದ್ರ ನೆಕ್ಸ್ಟ್ ರೋಸ್ಟರ್ ಅಲ್ಲಿ ಆಗೋ ಸಾಧ್ಯತೆ ಇದೆ.
ಅಲ್ಲಲ್ಲ
ಆಗ್ಬೋದಾ?
ತಮ್ಮ ರೋಸ್ಟರ್ ಆಗ್ಬೋದು ಸ್ವಾಮಿ.
ಆಗ್ಬೋದಾ? ಸರಿ, ಆಯ್ತು. ದ ರಿಕ್ವೆಸ್ಟ್ ಆಫ್ AGA call on 20th.
29.
Kindly extend the interim order.
ಆಯ್ತು, ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಇದ್ರೆ ನೋಡ್ಬಿಟ್ಟು ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡಿ. ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಇಫ್ ಎನಿ ಇಸ್ ಎಕ್ಸ್ಟೆಂಡೆಡ್ ಟಿಲ್ ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಆಫ್ ಹಿಯರಿಂಗ್. ಸರ್ ವಿ ಆರ್ ಟೋಲ್ಡ್ ದೆಮ್ ನೋ ಸರ್, ಇದಕ್ಕಿನ್ನ ಇನ್ನೇನ್ ಹೇಳೋದು ಸರ್, ಮಾಡ್ತಾರೆ ಬಿಡಿ.
ಅಲ್ಲ ಕಾಂಪನ್ಸೇಷನ್ಗೆ ನಾವು ಇದು ಮಾಡ್ತಾ ಇರೋದು, ಕಾಂಪನ್ಸೇಷನ್ಗೆ ಮಾಡ್ತಾ ಇರೋದು.
ಎಸ್, ಕಾಲ್ ದ ನೆಕ್ಸ್ಟ್ ಮ್ಯಾಟ್.
4 SP Prakash.
In view of the writ petition, writ appeal is pending before this Honorable Court, which was filed by the father of the petitioners, my lord. The above writ petition does not survive for consideration.
Okay, advocate for the petitioner submits that the writ petition has become infructuous. Full stop. His submission is placed on record. Petition is dismissed as having become infructuous.
5 Vani H.
Blood petition is filed, blood seeking a release of the compensation amount, blood which is awarded by the respondents. Representation given by the petition while filing the writ petition. I have filed an application, blood. There is minor correction, blood. In a day's time, I shall rectify it.
Writ petition.
Giridhar is there. Yes, my lord.
Writ petition may be allowed, my lords. I'm under instructions that
within an out frame.
The scheme under which these lands are notified has lapsed. My lords, it will take 2 months' time for payment of compensation. The writ petition is only for payment of compensation.
Yes.
In accordance with law, within a period of 2 months, my lords.
What is the amendment sought, madam?
They want to incorporate an additional annexure called annexure.
Representation given by the petition, one of the petitioners, my lord, for release
Okay,
of.
we'll
that's
allow
all.
the writ petition,
Lord.
they have to perform. We'll allow it. We are not
Please,
pressing
my
on.
lord. Please.
Yes, advocate for the petitioner submits that IA 1 of 2024 may be dismissed as not pressed. To stop. Accordingly, the same is dismissed. With the order sheet will ಬರ್ತಾ? Next to judgment. ಅಲ್ಲಿ.
Ajay Prabhu.
The case of the petitioners is that their lands have been acquired for formation of national highway, but compensation has not been paid. Award pass ಮಾಡಿಲ್ವೋ compensation pay ಮಾಡಿಲ್ವೋ?
Third ಆಗಿದೆ ಅದಕ್ಕೊಂದು ರಿಟ್ ಪಿಟಿಷನ್ ಆಯ್ತು. ಈಗ ದುಡ್ಡು ಕೊಡಿ ಅಂತ ಇನ್ನೊಂದು ರಿಟ್ ಪಿಟಿಷನ್.
Compensation has not been paid.
12,022.
Next para. The advocate for respondent number 2 to 4 upon instruction submits that award has been passed in respect of the lands which are the subject matter of the writ petition, and compensation will be paid to the petitioners if compensation will be paid to the petitioners. ಒಂದು ನಿಮಿಷ.
There is a change in name between the notification and the present writ
ಒಂದು
petition.
ನಿಮಿಷ ರೀ, listen to me completely.
Sorry.
Compensation along with due interest thereon, along with due interest thereon will be paid to the petitioners if they are able to establish that they are the sole owners of the lands in question. Otherwise, otherwise.
That wouldn't arise, my lord. I'm sorry, my lord.
I have to
Already
make
award
an-
note.
I
Award
have to
notices
make-
have been
I
issued to
have to
petitioners.
make an observation, madam. I'm making it. Otherwise, the same shall be deposited before the reference court. Full stop. Next para. Based on the submissions made by learned counsel for respondent number 2 to 4, respondents 2 to 4 are directed to determine the compensation.
That is all done,
Along
my lord.
with due interest thereon, and pay the same to the petitioners or deposit the same before the reference court within a period of 2 weeks from the date, 2 months from the
2
date
months.
of receipt of certified copy of this order.
Great.
Writ petition
One
disposed
submission,
of
my lord.
order. Yes, madam.
Award amount has already been determined. Award
That's okay,
notices
madam.
have been
will be-
issued.
That
Appli-
will be done in accordance with law, madam, because something may crop
I
up. We
placed
don't-
it before your lordships, my lord.
I cannot decide the dispute with regard to ownership, if any.
There
If
is no
anything
dispute.
crops
I
up-
do not know where
If
from
there
where
is
my
anything
learned
that
friend.
arises, it is left to the NHA. We can't expect them to.
That compensation is already determined in so far as the petitioners before your
Yes,
lordships is
madam,
what
I
I'm
have
saying.
disposed of the matter. Yes.
6, Saravana.
Lots by
Point,
orders
my lord.
dated,
1968.
lots by orders dated 31/10/23. There is already a order, not this IA should be considered along with the main. Not lordship may take this matter next week. not for the
1968
second week.
acquisition, my lord.
Really, first.
And 1971.
ಅಲ್ಲ, ನನಗೆ lots-
Pudal time. Really.
No, lordship may kindly pass it over. Lots. I have one matter, total one ಹೋಗ್ಬೇಕು, special matter.
ರೀ ಮತ್ ನೀವು ಬರಲ್ಲ.
ಅಲ್ಲ, ಬರ್ತೀನಿ.
ನೀವು ಎಸ್ಕೇಪ್ ಆರ್ಟಿಸ್ಟ್.
Kindly pass it over. lots.
ಕೇಸ್ ಇದ್ದಾಗ ಬಂದ್ಬಿಟ್ಟು ಇಲ್ಲಿ ಬಕಪಕ್ಷಿ ತರ ಕಾದಿ ನಮ್ ತಲೆ ತಿಂದಿ ಕೇಸ್ ನಡೆಸ್ತೀರಾ.
ಅಲ್ಲ, ಮಾಡ್ಸಿ.
ರವಿಶಂಕರ್ನು ಕರ್ಕೊಂಡ್ ಬರ್ತೀರಾ ಜೊತೆಗೆ. ಏನೋ ಕೇಸ್ ಇರ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಅಲ್ಲಲ್ಲ.
ಅಲ್ಲ,
Case
ಎಜುಕೇಶನ್
ಇರ್ಲಿಲ್ಲ
ಮ್ಯಾಟರ್
ಅಂದ್ರೆ
ಒಂದು
ಬರೀ
ಲಿಸ್ಟ್
ಇದೆ.
ಅಂತಾನೆ ತಗೊಳ್ತಾರೆ, ಫಸ್ಟ್ ತಗೊಳ್ತಾರೆ ಅಲ್ಲಿ ಕೊಡೋದು
ಅಕ್ರಾಂತ್.
ಇದಕ್ಕೆ.
ಇಲ್ಲ ಹೇಳಿ ಅಲ್ಲೇ ಪಾಸ್ ಓವರ್ ಮಾಡಿಸಿ. ಅಲ್ಲೇ ಪಾಸ್ ಓವರ್ ಮಾಡಿಸಿ. No, it has reached here. Show me first.
Not it has come for.
If you satisfy me on the ground of delay and latches.
I will satisfy.
No, satisfy here now. Do it.
No.
Do it. You are the advocate on record who has drafted
I will
the
do it. Must
petition.
kindly pass it over.
No passover counsel. Go on with the matter. Only a delay and latches. If you satisfy that, I'll give you adjournment also. No problem. First delay and latches. That's all. Show me.
Not only on delay and latches.
Only on delay and latches. If you satisfy me on delay and latches, with regard to merits, ನಿಮ್ಗೆ ಒಂದು ತಿಂಗಳ adjournment ಬೇಕಿದ್ರು ಕೊಡ್ತೀನಿ. Because it's a 2015 matter.
ಅಲ್ಲ, ಅಲ್ಲಿ ನಂಗೆ ಮ್ಯಾಟರ್ ಡ್ಯಾಮೇಜ್ ಆಗ್ಬಿಡುತ್ತೆ. ಸ್ಟೂಡೆಂಟ್ ಎಜುಕೇಶನ್
ಏನು ಡ್ಯಾಮೇಜ್ ಆಗಲ್ಲ.
allotment
ಪಾಸ್ ಓವರ್ ಕೇಳ್ತಿರಲ್ಲ,
ಹೌದು.
ಅಲ್ಲೂ ಕಳಿಸಿ ಪಾಸ್ ಓವರ್ ಕೇಳ್ಸಿ. ಎಸ್. ಕೇಳಿ.
Not 68 is the preliminary notification.
Hmm.
71 is the final notification.
Hmm.
Not they say, not the possession is taken on 1981.
Hmm.
Not possession till day continues to us. Not from 1988, there was a civil suit, OS 3510 of 1988. There was a litigation wherein I had an extent, not an interest in an extent of 22 guntas of the land in the suit property. That came to be declared in year 2007. Not even till today, the property continues to me with my possession and all my property, north, south, east and western.
ಆಯ್ತು 16 ಆಗಿದೆಯನ್ರಿ ಆಗಿದೆಯಲ್ಲ ಎಲ್ಲಾಗಿದೆ
ಅದು ಸೈಕ್ಲೋ ಸ್ಟೈಲ್ ಮಾಜರ್ ಅದು.
ಆಯ್ತು 16 ಮಾತ್ರ ಕೇಳ್ತಿರೋದು 16 ಕೇಳ್ತಾ ಇಲ್ಲ
26.
But and Mazar also indicate there is a private properties around my.
Okay, it's all right. 16-2.
R4 page 18, my lord. 16-2 is done on 2nd February 1982.
R4 page 18, huh?
Please. Relevant portion will be serial number 99.
Page number.
Page 19. Serial number 19 at page 19. Sir, statement of objection.
Now file ಮಾಡಿದ್ದೇನೆ sir.
Filed on 20th November 2018 file.
R4. Page number 18.
R4, page number 18 is the 16-2 notification.
Yes.
Relevant will be 99, serial number 99 on page 19.
33/2.
Yes, ma'am.
Okay.
Doctor, may kindly see the.
And award has been deposited, huh?
Yes, ma'am. Doctor, may also kindly see annexure B, the RTC which they produce.
B in the writ petition.
B in the writ petition. And B1, my lord. The notification of a CITV notified land ಅಂತ ಹೇಳಿ 1980 ಅಲ್ಲೇ RTC ಅಲ್ಲಿ ಎಂಟ್ರಿ ಆಗಿದೆ.
ಬನ್ನಿ. Yes. I heard you, Saravana. In the instant writ petition, in the present writ petition, in the present writ petition, the petitioners, although in the present writ petition and the petitioners are challenging the final notification issued on 28/10/1971 and final notification or preliminary notification? Final notification. Preliminary notification ಯಾವಾಗ?
3/6/1968.
ಈ ರೀತಿ ಮಾಡಿ. The petitioners are challenging the preliminary notification issued on 9/5/1968 and the final notification issued on 28/10/1971. And have prayed for setting aside the same insofar as it relates to lands of the petitioners are concerned. Full stop. Next para. The learned counsel for the government and the BDA both submit that the possession of the land has been taken and an order under section 16(2) of Land Acquisition Act has been passed.
Notification under 16(2) is published.
Notification order. Notification under section 16(2) of the Land Acquisition Act has been passed on.
Published on 2nd February.
Has been published on.
2nd February 1982.
2nd February 1982.
Yes.
Full stop. It is also submitted that
Award.
even prior to it, the award has been determined and deposited before the paid or deposited. Deposited before the reference court. Full stop. Next para. The writ petition is filed in the year 2016. The full stop. The inordinate delay of 38 years in challenging the acquisition proceedings has not been explained in the writ petition. Full stop. Next para. For the aforementioned reason, the writ petition is dismissed on the ground of delay and latches. Yes.
Serial number 7. Upana Nazir. Gopal V. Bidan.
Yeah, has been filed for release of the deposit amount made by the BBMP. BBMP had earlier made a claim over the property, my lord, but subsequently by virtue of joint commissioner's order, which is dated 17/2/2024, my lord, BBMP has waived off their claim over the property, my lords. The deposit is before this court, my lord.
Yes.
I have one submission to make in this. The petitioner is relying upon the order dated 17/2/2024 passed by the joint commissioner. The BMRCL has not been made a party to this. The total extent was 19,300 square feet, out of which 9,838 square meters have been acquired for the purpose of BMRCL. There was a title dispute between the petitioner and BBMP. Now, the petitioner claims that by this order, the petitioner has been declared to be the owner. But we are aggrieved only by one portion where direction is given to the assistant revenue officer to mutate the khata in the name of the petitioner in respect of the entire extent of 19,300 square feet, including the acquired portion. 9,838 square meters already stands in the name of BMRCL. Even that has been declared. The
order is along with the application dated 7/8/2024, my lords.
So if the petitioner can give an undertaking that they will not insist on khata in respect of the acquired portion, then I would have no objection because we have already deposited the amount.
The acquired portion is with them. By virtue of order dated 19/3, they were permitted to construct the metro station over the scheduled property.
That is there.
At this point of time, there is no point of claiming right over that property, my lords. We are claiming that we should be compensated with respect to that land also.
The fact of acquisition has not been brought to the notice of the joint commissioner. Therefore, he has passed this order. Therefore, if only the petitioner can give an undertaking that they will not claim a khata in respect of the acquired portion, then that will suffice my interest. We had initially paid the compensation amount to BBMP. Then by order dated 19/3/2021, BBMP was directed to deposit all the amount that they had received before this honorable court. The amount is in deposit before this honorable court.
Annexure Q is some letter written by.
Please reply, my lord. The legal notice issued by the petitioner, my lord, that has been
Setting it aside. Who is the owner of the land, I say?
Lords is the owner.
Then you are keeping your mouth shut without arguing.
My lords, I appear for BBMP, my lord.
No,
My
come
last
inside.
week we have filed NOC Vakala, Puttegoda Trittido. They're segregating the files. A week accommodation may be given. my
Then
lord.
why did you, I was about to pass the orders. What were you people doing? At the request of BBMP, finally, at the request of advocate for BBMP, finally, call on. Beggar date to what argument chale. No
17
further adjournments.
11 months.
Huh? No
11th
further
month.
adjournments.
Yes,
Take a
my
date of your choice. I'm
Yes, my
giving you.
lords. My lords.
Call on
11th.
11th. Yes.
8 RP Somasekaraya, Narayan Babu.
ಸ್ವಾಮಿ ಇದು ನಿಮ್ ರಿಟ್ ಪಿಟಿಷನ್ ನಿಮ್ ರಿಟ್ ಪಿಟಿಷನ್ ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್ ಹೇಳಿ ಅದನ್ನ ಅಲೌ ಮಾಡ್ಬೇಕು ಡಿಸ್ಮಿಸ್ ಮಾಡ್ಬೇಕು ತೀರ್ಪು ನೀಡೋಣ ವೆಕೆಟಿಂಗ್ ಸ್ಟೇಗೋಸ್ಕರ ಏನ್ ಬೇಕಾಗಿಲ್ಲ ಆರ್ಗ್ಯೂ ರಿಟ್ ಪಿಟಿಷನ್
The respondent in Malad has acquired the land bearing survey number.
ವಾಟ್ ಇಸ್ ಅನೆಕ್ಷರ್ ಸಿ
Annexure C is the Malad notice issued calling upon me to hand over possession of the property to demolition Malad. Annexure page number C Malad. Page number 49, annexure C. ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸರ್ ರುದ್ರಾಣಮ ಕೋಮ್ ಲೇಟ್ ರವಿಕುಮಾರ್ ಆದ ನಿಮಿತ್ತ ಈ ಮೂಲಕ ಚಿತ್ರದುರ್ಗ ಗ್ರಾಮಾಂತರ ಜಿಲ್ಲೆ ಯಲಮಂಗಲ ತಾಲೂಕು ಸೋಂಪುರ ಹೋಬಳಿ ಚಂದ ಹೊಸಳ್ಳಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 21/2 960 ಚದರ ಮೇರೆಗೆ ಸ್ವಾಧೀನ ಕಾಲಂ 3D ಮತ್ತು 3D2 ಅಧಿಸೂಚನೆ ಭಾರತ ಸರ್ಕಾರ ರಾಜ್ಯ
ಪ್ರಿಲಿಮಿನರಿ ನೋಟಿಫಿಕೇಶನ್ ಎಲ್ರಿ ಇದೆ
notification annexure. That page number 42 is my relevant portion, my lord. Annexure B.
No, where is the preliminary notification?
My lord, exactly ನನ್ನ land acquired ಆಗಿಲ್ಲ.
I to show the preliminary notification, that's why I am asking.
Page number 42, my lord.
Respondent,
They have
Please, my
admitted
lords.
it,
show the preliminary notification and final notification.
Please, my lords, here what has happened is the survey number, the survey number which was acquired was survey number 2A/1. But however, in the notification that has been wrongly misplaced as survey number 1/A1, my lords. So due to this advantage has been taking, the stay came to be granted. Precisely for the reason I've just mentioned it in the statement of objections also, my lords.
Show
And
me the preliminary notification.
I'll place the records, my lords. I have not produced a notification. It may be taken up tomorrow, my lords. I shall place the notification. And also I'll also place the communication.
Show the preliminary notification and final notification.
Please, my lords.
And show that this land has been acquired.
Please, my lords.
Okay.
What
If
had
you
happened
fail
is
to
this,
do
in
so-
the initial preliminary notification, there came to be a typographical error that been made up. And that was further rectified in another notice, my lords. And that was also communicated to the petitioner also then.
Show all those things.
Please, my lords. It may be taken up tomorrow or day after, subject to the convenience of this honorable court, my lords.
Yes, next week on date ಕೊಡಿ.
My name is shown, it may be deleted.
ಯಾರ್ದು?
Respond number 1 to 3, my name is shown, it may be deleted. For respond number 1 to
Registry to delete the name of Shri Shobit and Shetty as the advocate appearing for R1 to R3.
Narayan Babu R1, R3 ge Sudarshan Suresh.
2 and 3.
2 and 3 Sudarshan Suresh.
Sudarshan Suresh, 2 and 3.
Right.
interim order to continue. my lord.
Interim order of any is extended till next date of hearing. Call on 99.
Grateful, my lord.
Interim
Interim
order
order
to
of any is extended till next date of hearing. See, he is not challenging any of the notifications.
Please, my lords.
Okay. He is challenging only the letter issued by you
Please, my lords.
to deliver possession.
Please, my lords.
So if you are able to establish that there are notification to the effect showing that the lands have been acquired, the
Please,
petition
Lords.
will be dismissed.
Please, my lords.
But if you fail to show that there are notifications to show that lands of the petitioners,
Have not been acquired.
then in
Please,
that
my
event,
lords. I shall demonstrate it, my lords.
we will quash your
I shall demonstrate it before, my lords.
allotment.
I shall demonstrate.
That's how it's going to happen.
Apart one, that is my, apart from that, my lord, now, my lord, since the, your lordship kindly turn to annexure, team.
ಸ್ವಾಮಿ ಈಗ ಅಡ್ಜನ್ ಆಗಿದೆ.
ಅಲ್ಲ ಅಲ್ಲ ಅದು ನಾವು ಇಲ್ಲಿಂದ ತಕ ದೊಡ್ಡ ಹೋಟೆಲ್ ಇವರೇ ಮಾರ್ಕ್ ಮಾಡಿರೋ ದೊಡ್ಡ ಬಿಟ್ರೆ ಫುಲ್ ಬಿಲ್ಡಿಂಗ್
Sir, listen,
ಪ್ಲೀಸ್ ಬರ
if you are not challenging the notifications, acquisition notification.
ನೋಟಿಫೈ ಮಾಡಿಲ್ಲ ಅದು.
ನೋಟಿಫೈ ಮಾಡಿಲ್ಲ ಅಂದ್ರೆ ನಿಮ್ ಕೇಸ್ ಅಲೋ ಆಗುತ್ತೆ. ನೋಟಿಫೈ ಮಾಡಿದ್ರೆ ಕೇಸ್ ಡಿಸ್ಮಿಸ್ ಆಗುತ್ತೆ. ನೀವು ನೋಟಿಫಿಕೇಶನ್ ಚಾಲೆಂಜ್ ಮಾಡಿಲ್ಲ.
ನಮಗೆ ನೋಟಿಫಿಕೇಶನ್ ನಮ್ ನೋಟಿಫೈ ಮಾಡಿಲ್ಲ ಅಂತ ನಮ್ದು.
ನಿಮಗೆ ನೋಟಿಸ್ ಕೊಡೋ ಅವಶ್ಯಕತೆ ಇಲ್ಲ. ಖಾತೆದಾರಿ ಕೊಟ್ರೆ ಸಾಕು.
ನೋಟಿಫೈ ಮಾಡಿ ಅಬ್ಜೆಕ್ಷನ್ ಕಾಲ್ ಮಾಡ್ಬೇಕಲ್ಲ, ಅದು ಮಾಡಿಲ್ಲ ನಾವು.
ಆಯ್ತು ನೋಡೋಣ. ಅದನ್ನ ಚಾಲೆಂಜ್ ಮಾಡ್ಬೇಕಾಗತ್ತೆ ನೀವು. ಅದನ್ನ ಚಾಲೆಂಜ್ ಮಾಡಿಲ್ಲ ನೀವು.
ಅಲ್ಲ ನಮಗೆ ಇದು ಎಕ್ಸೆಪ್ಟ್ ಅನ್ನೆಕ್ಸರ್.
ಆಯ್ತು, let us see on 9th. Yes.
Grateful, my lords.
9, Rachita DJ.
For respond 1 and 3.
Kindly grant a week time, Your Honor.
So respondent, my lords, I am the allottee, my lords, and the beneficiary of the acquisition. They have obtained an interim order of stay, my lords, and they're coming in the way of development now. Their land, my lords,
Argue your matter.
Need to serve a copy, Your Honor, after.
You need not serve. You won't serve. You have taken an interim order and it's a 2023 matter. You are not serving copies on anybody.
Kindly short accommodation, Your Honor.
ನಾಡದ್ದು
These ones.
ನಾಡದ್ದು ಕೊಡಿ, ಕಾಪೀಸ್ ಎಲ್ಲ ಕೊಡಿ. ಆಮೇಲೆ ಕಾಸ್ಟ್ ರೇಟ್ ಅಮೆಂಡ್ಮೆಂಟ್ ಮಾಡಿಲ್ಲ.
Next Monday, Your Honor, kindly, Your Honor.
Why Monday?
Your Honor, one short accommodation.
Why Monday, madam? See, it shows that you obtain interim orders behind somebody's back and you do your best to drag the proceedings. That's what you are doing.
Monday without fail, Your Honor.
The request of petitioner finally call on Monday date ಕೊಡಿ.
Nine.
No other.
To be extended.
Interim order, if any, is extended till next date of hearing. No further adjournments.
Okay,
If you don't comply, needful by then anta ಮಾಡಿ. Needful by then. Okay. If you don't serve a copy, if you don't carry out the amendment, I am going to dismiss your writ petition. Yes.
Grateful minutes.
10, SK Acharya, PV Chandrasekhar.
For the petitioner, my lord. I filed application for certain additional documents may be taken along
ಏನ್
with the main
ಬೇಕಾಗಿಲ್ಲ ಅದನ್ನ we'll consider it at the time of final hearing. ಹೇಳಿ, go on with your matter.
Please, my lord. SO is not filed, my lord.
ಚಂದ್ರಶೇಖರ್.
ಇದರಲ್ಲಿ acquire ಆಗಿದೆ the company petitioner company has become right up with the sovereign court. The company petitioner the company mala that has been going to the sovereign court. The sovereign court directed us to depart the entire company for the official liquidator. We have departed the entire amount before the official liquidator. And these petitioners have no right to come in the way, my lord. Because they have to go before the official liquidator, the entire company, they can seek only for their only, my lord.
And also.
They are not
acquisition
submitted
made on
anything,
84,
they are not
my lord.
submitted anything in writing, my lord, with
acquisition.
regard to the objections, my lord. They are
Yes,
not
go on with the
submitted.
matter, Mr. Acharya.
My lord, I am not ready today, my lord, because I thought that others
No
say he said
adjournment.
he-
Sorry, sir, no adjournment.
Well, he
You have
submitted
taken
that.
interim order, no? You have taken interim order.
Well, he submitted that, well, he is going to file the objection statement, my lord.
Please
Kindly
go on with
appreciate
your
this,
matter. You have filed your writ petition. Show how your writ petition is maintainable.
my lord. Today I am out of station, my lord. Stay held up in
Doesn't
native
matter.
place,
ಹೇಳಿ
my lord.
ಹಾಗೇನೆ.
Well, that, disabled, my lord, because my wife is admitted to hospital. I am in Udupi, my lord. That's why Yalash may have next week, my lord. I am disabled. That is why I am making submission, my lord. Today, my lord. Yalash may have to 19th.
The request of petitioner finally call on 9th.
19th, my lord. 19th, my lord.
9th.
19th, my lord. 90 illa Swami. Or 10th, Yalash may have 10th, my lord. 10th.
Right, 10th.
Please, my lord, please.
11, Srinivas Rao, BN.
Last year document ತರ್ಸಕ್ ಹೇಳಿದ್ರಿ. ಡಾಕ್ಯುಮೆಂಟ್ ತರ್ಸಕ್ ಹೇಳಿದ್ರಿ. ಹೇಳ್ತಾರೆ.
Object, my lord, it should be filed, we require for the, my lord, to file a statement of objection, because, my lord, the matter regarding, my lord, in the year of 1937, my lord, before independence, my lord, acquisition is made by the government, my lord. The lords, my lord, kindly see, my lord, remand the matter and also,
No.
my lord, want to file objections on that.
The request of AGA call on. Call after 2 weeks. Objections if any by then.
12, Shiv-Prasad Shantanagowda.
For the petitioner.
Yes.
Petitioner's land was acquired by KDP. Petitioner's land was part of preliminary notification dated 2020. Thereafter, my lord, in the final notification, my lord, the petitioner's land was not acquired. Thereafter, my lord, we issued a representation seeking a NOC from them. Since my land is not acquired in the final notification, kindly issue an NOC. That NOC, my lord, came to be rejected, saying that, my lord, your land will be subject matter of future acquisition, because of which we can't give you NOC now. 2020 is the preliminary notification. The endorsement which has been issued, which is the order impugned before your lordships, is at Annexure F, page 186. That is also dated 9/3/2023. Even as of today, my lord, there is no final notification issued insofar as the petitioner's land is concerned. My lord, this court has on multiple occasions held a 2 years period, my lord, is sufficient for issuance of final notification. Kindly see the date of preliminary notification 2020. And now we are in 2024. Now, my lord, without final notification, now what has happened, my lord, at the time of hearing, there is no threat of disposition or anything. Now, my lord, without a final notification, they are coming into the petitioner's property and they are trying to take possession. Now, seeking a disposal of this petition, there are covered judgments, my lord. Judgments are also very clear. When this court on multiple occasions have held that, my lord, 2 years.
Endorsement ಎಷ್ಟನೇದು annexure?
Page 186, Annexure F.
ಅಲ್ಲ, you have sought for annexure F ಅದು.
Yes, my lord, Annexure F, page 186.
ಇದು ಬಿಟ್ಟಿದ್ದೀರಾ ಇಲ್ಲಿ?
This is the reply given to my presentation, last paragraph. Might kindly be seen. Last paragraph, my lord. ಈ ಕಚೇರಿಯ ಭೂ ಮಾಪಕರು ನೀಡಿರುವ ವರದಿಯಂತೆ ಹಾಗೂ ಲಭ್ಯವಿರುವ ದಾಖಲೆಯನ್ನು ಪರಿಶೀಲಿಸಿ ಕೋಲಾರ ಜಿಲ್ಲೆ ತಾಲೂಕು ವೇಮಗಲ್ ಹೋಬಳಿ ಮಲ್ಲಿಯಪ್ಪನಹಳ್ಳಿ ಗ್ರಾಮ್ಯ ಸರ್ವೆ ನಂಬರ್ ಸೋನ್ಸರ್ಲಿ ಒಟ್ಟು 1 ಎಕರೆ 30 ಗುಂಟೆ ಜಮೀನು ಪ್ರಾಧಿಕಾರ ಅಧಿಸೂಚನೆಯಲ್ಲಿ ಪ್ರಾಥಮಿಕ ಅಧಿಸೂಚನೆ ಒಳಗೊಂಡಿದ್ದು, ಈ ಪೈಕಿ ಸರ್ವೆ ನಂಬರ್ 35 ಪೋಡಿ ದುರಸ್ತಿ 37/11 ರಲ್ಲಿ 0.35 ಗುಂಟೆ ಜಮೀನು ಸರ್ಕಾರದ ಅಂತಿಮ ಅಧಿಸೂಚನೆಯಲ್ಲಿ ಬಾಕಿ ಇರುವುದಾಗಿ ತಿಳಿಸಿರುತ್ತಾ ಎಂದು ತಿಳಿಯುವುದು. So my land is not acquired, 37/11. When I sought for issuance of NOC, they say that, my lord, in future it will be acquired. Now 2 years, my lord, has lapsed. But
Yes,
2
we'll
years
set
later-
it aside.
My lord, I'll take instruction and file objection, my lord, one submission. The issue what had happened is when the notification was passed, there was no sub-coding. It was 37/5, 1 acre, 30 guntas. Your Honor may go to ink page 45, Your Honor. Preliminary notification, serial number
I'll call it on
63.
Thursday. You file your objections.
My lord, I filed wakalat last week. At least 2 weeks time may be given.
No 2 weeks and all. Monday, max to max.
In the meanwhile, not let them not disturb the status quo be maintained. That is all I'm asking.
Because,
yes,
my lord, the issue what had happened is, during my final notification, the POD has taken place. The boundaries with regard to both the survey numbers are same.
Look, counsel, the only thing to be looked into is whether final notification has been issued or not.
Yes, sir.
If final notification is not issued, the preliminary notification will also go, your endorsement will go.
What I was trying to tell is the boundary in the final notification and preliminary notification is same.
You take your time. Yes, at the request of respondent number 2 and 3, call on 10th, I'll put it.
Much obliged.
Okay, call on 10th. Parties are directed to maintain status quo in respect of the property concerned till next date of hearing.
Much obliged.
Yes.
Great.
13 adjourn. 13 adjourn, 14. 13 no.
ಯಾರು ತಗೊಂಡ್ರು ಟೈಮ್?
13 minutes. 13 now no one else.
13 ಯಾರು ತಗೊಂಡ್ರಪ್ಪ? ಯಾರು ತಗೊಂಡಿಲ್ಲ?
ಯಾರು ತಗೊಂಡಿಲ್ಲ.
13.
ನೀವು ರಾಂಗ್ ಆಗಿ ಮೆನ್ಷನ್ ಮಾಡ್ಕೊಂಡಿದ್ದೀರಾ.
ನಾವು
13 ಯಾರು
mention
ತಗೊಂಡಿಲ್ಲ?
ಮಾಡಿಲ್ಲ.
Okay, 13.
All the parties are here, no?
But this is a case where the land was petitioner's father purchased the property. There are 3 cell it 48, 50 and 53. Then my lords, it is an inam land. The 3 cell deeds, my lord, was 14,148, 3,1050, 7,954. Then my lord, there was a re-grant order on 30th of December 1972. Annexure A, my lord. Then thereafter, my lord, the Kata has been affected and the land came to be acquired by the KDB. And in the notification, it shows Sarkari Pada. But we have given an application from 98 onwards. Of course, the time was extended till 2014. And I placed it on record. And that application, my lord, is still pending. And there is a mandamus by this honorable court, my lords, in 2019 itself. Sorry, madam. That the application has to be disposed of. Now, my lords, my locus to challenge this notification would arise only when these proceedings are decided in my favor. That's the position. They will have to hold an inquiry.
Now, 2006 and 2008 notification, why do you want it to be set aside?
Of course, my lord.
On what
your
grounds you
lordship-
are asking for setting aside the notification?
Not there is, now in the revenue records, it has been shown as.
Sir, ownership is different altogether.
Lord, now they want only compensation, they can not. That is so.
Notification, my lord, we are only entitled for compensation.
No, you asked for setting aside the notification.
Yeah,
That
he
is
asked,
why, my lord,
but he has asked,
that
but
is why
not, my lord,
quashing of the notification comes into the picture only when the Sarkari Pada has been set aside or restored by the deputy commissioner. The deputy commissioner writes a report to the government saying that this application.
You pursue your remedies. I'll dispose of the writ petition recording those things. Bunny, the
Lord, all that I want is, in the event of, my lord, the success before the revenue officer, in terms of the mandamus, the liberty may be granted to claim the compensation. That's it.
not for them. What if an example? ಅಪ್ಲಿಕೇಶನ್ ಇದೆ ಅಂತ ಹೇಳಿದ್ರೆ ಯಾವ ಅಪ್ಲಿಕೇಶನ್ ಅಂತ ಹೇಳಿಲ್ಲ ಸರ್ ವೆದರ್ ದೇ ಪಿವನ್ ಅಪ್ಲಿಕೇಶನ್ ಆರ್ ನಾಟ್
ಕೊಟ್ಟಿದ್ದೀವಿ.
ಪ್ಯಾರಾ ನಂಬರ್ 5 my lord.
Blood, I filed an application producing the
What is rule 119 of Karnataka land revenue rules?
rule 119, my lord.
Land revenue rules told.
Oh,
119.
Rule 119.
Restoration forfeited occupancy. Deputy Commissioner, District Bangalore, Urban.
ಇದ್ರ ಮೇಲೆ ಸರಿಯಾಗಿ ಪ್ರಿಪೇರ್ ಆಗ್ಬಿಟ್ಟು ಆರ್ಗ್ಯುಮೆಂಟ್ ಹೇಳಿ.
Please, madam.
Rule 119 ಬಗ್ಗೆ.
Government has to.
See, we are required to decide
Please, madam.
whether
Acquisition.
the right is only eclipsed or he loses the right.
In respect of my lord, my.
But this time was extended till 2014. We filed an application 98/2004. I applied 7th of May 2014 is the last application. We have originals. Along with the application, I filed. 10th June 2014, blood in this, I produced all the documents. The Tahsildar submits a report, we are cultivating the land.
Government. Toti Nam land, my lord, they say that, my lord, is granted to him.
No.
Lord, the question is, your lordship kindly take, Lord, section
I
94.
want you to file your objections to government
Please, my lord.
in this matter. See, what happens, land belongs to him, that's what his claim is. Then subsequently it is forfeited by the state.
Yes.
On the ground that land revenue has not been paid. Then he makes an application for restoration under section rule 109. In the meanwhile, land gets acquired.
Please.
Okay. Now, in the light of acquisition, does his right to survive? Is what has to be looked into. It requires an element of research and
Please.
assistance.
My lord, so far as restoration is concerned, mere entry in the pada, my lord, that it is Sarkari pada, would not divest the title of the owner.
That's his
In fact,
contention.
the full bench of 1954 itself, unless the property is sold and proportionately, the rest of the money should be refunded to the owner. Then only it vests with the government.
That's the
That's
reason.
position.
That's the
I
reason.
will assist your lordships on that.
That's the reason why I'm asking them to get
I'm
rid of this
grateful.
matter. Okay. See, what is the effect of it? The question of setting aside the notification does not arise.
Arise.
The onus now is on you.
Whether they are entitled for the compensation, Lord,
No.
They are entitled for
subject to
compensation or
the
not.
application pending.
Ah.
for the-
Will they have any right on the land or not? That needs to be gone into.
Lord, as per, Lord,
Whether the right of the owner is divested merely because, when it is divested, it is only when the property is sold under section 163.
That
Please, my lord.
government needs to argue.
Please.
Now it's a fight between the government and the petitioner.
in cases of.
And I found out, blood,
Cases of
Yesterday-
unauthorized occupation, my lord, the land has to be granted, my lord, before, my lord, the notification on 28/1, my lord, issued on session 94. My lord, this is
Unauthorized
different case.
No, it's not unauthorized occupation.
That is correct, my lord.
See, if it is unauthorized occupation, there is no accrued right in favor
Yes,
of
yes, correct.
the petitioner as such.
Please, my lord.
Okay, that's
But
the
here is the case, my
that
lord,
I
is
have taken.
different, stands in different.
Here is a case wherein it's a question of grant.
Correct.
Re-grant, there is a sale deed. And the Sarkari revenue entries ಅಲ್ಲಿ ಪಡ ಅಂತ ಬರೀತಾರೆ.
To cancel.
If the government may not take steps under section 163, bringing the property for proclamation of sale, if the sale has taken place, sale proceeds are appropriated, then only the land vests with the government.
We'll make our submission.
I'll
right?
call him for 2 weeks.
Please.
Get ready in this matter.
2 weeks, my lord.
Make proper research. on
Please,
it.
please.
Yes, at the request of EG, call on. Date put in.
Of course, yesterday I found out, my lord, there is a recent judgment of His Lordship Justice Sanjay Goda under Rule 109. Unless the property is sold, it won't vest. I will.
You give them those copies also.
Yes.
So
And I mentioned 1954 full bench judgment in
20th.
the writ petition itself.
20th.
20th. Yes.
For the response.
ಶೇಷಿಗೆ ತಾವು ವಯಸ್ಸ 14.
There is one factual clarification which possibly if the government can tender minutes, that the argument can begin on those lines. One of them minutes says, minutes, it's the preliminary notification minutes is dated 1/9/2010. Then minutes there is a final notification minutes which is dated 11/10/2012. There is a time gap. Minutes, if there is a publication in between minutes because beyond the statutory period stipulated in 4 minutes, the notification could not be issued.
That your lordship already held, my lord, recently, that my lord, the last date of my lord publication of notification is
Correct.
relevant
What
to
is,
the-
I just, minutes, that factual detail of the last date of publication is what I stand. Then minutes, I'll have to take a different stand. Because this is statutory in its nature. That is not available or made available on record. So in this case, minutes, we had raised that plea during the course of arguments. The last occasion also.
Now, if people are ready, I'll take it up. Are you ready?
So that detail, one detail minutes with respect, to otherwise my course of arguments will vary minutes.
Look,
I'll have to go on a different course. I'll have to go on
when do you want?
date of date of publication. If it, that can be tendered minutes next week, any day minutes, we can go ahead with that.
Kotpudi Pradeep.
Date of,
The request of parties, call on. 10th hakuva?
minutes,
10th.
would it be any day after 13th? 13th.
18th.
Great.
ಆಯ್ತು.
Date of publication.
ತಾವೇನೋ ಸೆಟ್ಲ್ಮೆಂಟ್ ಅಂತ ಲಾಸ್ಟ್ ಟೈಮ್ 50-50 ಲ್ಯಾಂಡ್ ಶೇರಿಂಗ್ ಬರ್ತೀರಂತ.
ಒಬ್ರು ಒಪ್ತಾ ಇದ್ರೆ ಒಬ್ರು ಒಪ್ತಾ ಇಲ್ಲ.
ಆಯ್ತು, ಒಪ್ಪಿಲ್ಲ ಅಂದ್ರೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡು.
Where is the property situated?
ನೆಲಮಂಗಲ.
Nelmangalam. Green belt.
Lord, we
One
offered,
of the
my lord, 50-50 land sharing.
What, this is KHB, is it?
KHB.
We offered, my lord, some of the, my lord, petitioner came before this court and filed, my lord, application and they, my lord,
ಅದು ವಿಚಾರ ಮಾಡೋಣ ಬೇಕಿದ್ರೆ if they'll please put it across. With reasonable compensation, they may always be lured.
Excellent.
50-50 is fantastic, lord. What we
No,
can-
my lordship was
best offer
telling
what we
something.
can-
So 50-50 is an excellent.
I'll just put that across. I'll just put that.
Lord, in the
So
same
that-
batch of, my lord, cases, my lord, 24 acres, my lord, landowners, my lord, came before this court, my lord, agreed and, my lord, their cases, my lord, dismissed, my lord, because they opted, my lord, 50.
On a compromise.
That is the compensation.
See, ಏನಾಗೋದು ಗೊತ್ತಾ? These people tend to fix
6 ಲಕ್ಷ 3 ಲಕ್ಷ ಫಿಕ್ಸ್ ಮಾಡಿರ್ತಾರೆ.
the rate also
Rate.
per square feet,
Yes.
which becomes the sub-registrar valuation also.
My lord, 50-50 is, my lord, is more than the compensation, my lord.
And see what happens, they come up with a scheme like you can immediately sell it to whomever you want.
Correct.
Number one. For that, there is no tax.
Correct.
Yes.
Good.
Okay,
It's
number
virtually a
2.
joint development, not set
Number two,
free of.
they will directly register it to those persons.
Landowners.
Yarge, whom
Oh.
you tell them to register.
Yes.
For them, they will save on stamp duty.
Correct. So the
The-
real,
The sale made by them. ಈಗ ನಿಮ್ಮ ಹೆಸರು ರಿಜಿಸ್ಟರ್ ಮಾಡಿಸ್ಕೊಂಡು ನೀವು ಸೇಲ್ ಮಾಡಿದ್ರೆ ಸ್ಟಾಂಪ್ ಡ್ಯೂಟಿ ಕಟ್ಟಬೇಕು.
correct. In other words, my lords, the liaison
So
or
that
the
is the
brokerage
scheme,
charges
right?
will also be saved.
Huh?
In other words, the liaison charges or brokerage charges will also be saved.
Yeah. See,
I got it.
even the cost of acquisition will be much lesser than, which will be more than
Correct.
hitherto market value.
Correct. Correct.
See, the cost of acquisition, what they offer will be more than hitherto market value. Number one. Number two, the 50-50 sharing ratio, taking into consideration the sub-registrar valuation, will be more than the compensation amount that you will be getting.
Correct. That is definitely there. ಏನಾಗಿದೆ ಈ
See,
private developers, they are offering it 60-65%. That is where, this is the only percentage lure.
I'll tell you what, private developers, ಒಂದು ಅವರು ಡೆವಲಪ್ ಮಾಡೋದ್ರ ಚಂದ ಅಷ್ಟರಲ್ಲೇ ಇರ್ತದೆ. First one, element of this trust is
Security.
not there.
Trust deficit.
Trust is not there. ಮನ್ಸಿಗೆ ನೆಮ್ಮದಿನೂ ಇರ್ಬೇಕಲ್ವಾ at the end of the day. That will not be there.
Correct.
And value of the property, my lord,
Ah,
always,
see,
my lord.
what happens when you sell the property by getting from them directly? See, you can ನಿಮಗೇನ್ 50% ಬರ್ತದೆ, ಆದ್ರೂ 50% ನೀವು ಸೇಲ್ ಮಾಡಿದ್ರು you will get the cost of your land. ಇವತ್ತು ನಿಮ್ ಲ್ಯಾಂಡ್ ಹೊರಗಡೆ ಮಾರಿದ್ರೆ ನಿಮ್ಗೆ ಏನ್ ರೇಟ್ ಸಿಗ್ತದಲ್ಲ, ಅದ್ರಲ್ಲಿ 50% ಸೈಟ್ ಸೇಲ್ ಮಾಡಿದ್ರು you get the cost of your land.
Yes.
In 50% site will remain free for you. ಅವಶ್ಯ ಬಿದ್ದಾಗ ಒಂದೊಂದು ಸೇಲ್ ಮಾಡ್ಕೊಂಡು ಮಾಡ್ಕೊ. ಬಟ್ ಏನಾಗುತ್ತೆ ಅಂತ ಹೇಳಿದ್ರೆ, ಇಫ್ ಇಟ್ಸ್ ಎ ಜೆನ್ಯೂನ್ ಫಾರ್ಮರ್ landlord, it makes sense.
They will have that hard.
But if you are a secondary guy, in the sense
Investment.
middleman who is trying to make
This is the best offer. This is the best offer. For age-old farmers, it's a real heartburn.
no heartburn actually.
For age-old farmers.
No heartburn. This generation will not have any heartburn.
ಏನಾಗೋಗ ಕೆಲವು farmers, they still depend on that as a livelihood. Some families.
Correct. They can go and buy land elsewhere.
Some families. Which means they'll have to shift the entire village, they'll have to shift out to some other place. That's the heartburn.
That's all.
I'll just put that across.
Please. 15 adjourn, 16 adjourn, 17. Kiran J. 17. Kiran J. RV Jai Prakash.
Petitioner, my lords. The acquisition, my lords, is challenged on the ground that it has lapsed. Now, my lords,
RV Jai Prakash.
earlier round, my lords, we had challenged the acquisition. Matter went up to the Honorable Supreme Court. We lost it on merits. Now, my lords, then we find that after all that, during the pendency of SLP, my lords, before the Honorable Supreme Court, the state had ventured to again acquire it for nice under KDB acquisition. So that was brought to the notice of the Honorable Supreme Court. Honorable Supreme Court, my lords, only observed that in case such a thing has happened, that would virtually nullify the acquisition which your lordships would get at page.
First, it was sought to be acquired just for public purpose.
My lords, the preliminary notification was for a link road for KSRTC.
Okay.
My lords, they invoked emergency clause, then they gave up and they gave a hearing under 5A. Final notification was KSRTC, labor and the quarters and workshop. So we challenged that, saying that preliminary notification was for a different purpose, final was for a different purpose. Anyway, this honorable court, single judge allowed the writ petition, but ultimately the division bench allowed the writ appeal of the KSRTC. We went up to the Honorable Supreme Court. Supreme Court confirmed the view of the, in the sense upheld the acquisition, my lords. Review was filed, review also came to be dismissed. But in the meanwhile, my lords, this portion of land
was also sought to be a portion of this land was sought to be acquired for nice. This was brought to the notice of the Honorable Supreme Court. That, my lord, the Honorable Supreme Court only observed that if such is the case, then it would please come to page. It starts at 45. The Supreme Court's order starts from page 45. A list of citations and that has a better order copy, my lord, because this seems to have gone all over the place.
Produced it along with.
We have produced it along with our list of.
Statement of objection.
ಆಯ್ತು ಇದೆ ಎಲ್ಲ ಒಂದೇ ಬಿಡಿ ಇದೆ ಯಾಕಂದ್ರೆ ಇದು ಸ್ವಲ್ಪ ಹಿಂಗೆ ಎಲ್ಲ ಹೋಗ್ಬಿಟ್ಟಿದೆ ಆರ್ಡರ್
This is legible.
ಲೆಜಿಬಲ್ ಕಾಪಿ ಇದೆ ಲಿಸ್ಟ್ ಆಫ್ ಇಲ್ಲ ಅವ್ರ ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಅಲ್ಲೂ ಇದೆಯಂತ ಇಲ್ಲ ಅಂದ್ರೆ ನಮ್ ಲಿಸ್ಟ್ ಆಫ್ ಸೈಟೇಷನ್ಸ್ ಹಾಕಿದಿರಲ್ವ ಬೇರೆ ಇದು ಬೇರೆ ಇಲ್ಲ ಅಂದ್ರೆ ಮೆಮೊ ಫಾರ್ ನನ್ನ ಕಾಪಿ ಮಿಕ್ಸ್ ಮಾಡಬೇಡಿ ಮೆಮೊ ಫಾರ್ ಪ್ರೊಡಕ್ಷನ್ ಆಫ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಅಲ್ಲಿ ತಮ್ಗೆ ಅದು ಇಟ್ಸ್ ಡೇಟೆಡ್ 31/7. ಐ ಆಮ್ ಟೋಲ್ಡ್ ಇಟ್ಸ್ ಫೈಲ್ಡ್
31/7 ಅಂತ ನೋಡಿ.
ಮೆಮೊ ಫಾರ್ ಪ್ರೊಡಕ್ಷನ್ ಆಫ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಅಂತ ಹಾಕ್ತೀನಿ. ಇಲ್ಲ ಅಂದ್ರೆ ಇನ್ನೊಂದು ಕಾಪಿ ರೆಡಿ ಇದೆ ಇಲ್ಲಿ. ಇಲ್ವಾ? ಅದರಲ್ಲಿ ಪೇಜ್ 21 ಅಲ್ಲಿ ಇದೆ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ 31/7/2023 ಅಂತ ಮೆಮೊ ಫಾರ್ ಪ್ರೊಡಕ್ಷನ್ ಆಫ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ನಿಮ್ಗೆ ಕೊಟ್ಟಿಯಾರ ಸರ್? ಸರ್ ನಿಮಗೆ ಕೊಟ್ಟಿದ್ದಾರೆ ನಮಗೆ ಕೊಟ್ಟು ಕಣ್ ಪ್ರಾಣ ತೆಗಿತಿದ್ದಾರೆ. Just place it,
citation.
It's an unreported thing, but starts at page 21. That's running page 21 in that Supreme Court order. In that, my lord, the Honorable Supreme Court upheld the acquisition. Then, my lord, please come to para 13 onwards. At page 29. It starts with so far as the lordship gets me. So far as 39 guntas covered by survey number 128/1 is concerned, which is sought to be acquired as indicated from letter dated 10/12/2004. We find same is not included in final notification. Bare perusal of notifications issued under 4(1) and 6 would indicate that the land covered by survey number 128/1 was a part of the said notification, but since the same came to be excluded in the final notification under 28(4), contentions raised by counsel appearing for appellants that the land stood acquired for a different purpose and therefore purpose for which the land sought to be acquired under 4 and 6 was unjustified is not tenable. Then please see 14, my lords. Even other, then my lords, their lordships say all that. But please come to para 15. However, on a close scrutiny of records, we find that the same is not the case in the present case on hand. It cannot be said that the land which stood acquired under notification issued under 4 and 6 of the Act are in any manner connected with the notifications issued by the state government for Karnataka Industrial Areas Development Board for Bangalore-Mysore Infrastructure Corridor Project, and even assuming a part of the said land is now sought to be acquired for a different purpose, to that extent the same cannot be said to be a proper acquisition, as the land already stands acquired under a different notification issued by a separate authority under separate provisions of law. Now, under the notifications, we have pointed out that the very same land which is acquired under section 4 and 6 has now been acquired under 28(1) and 28(4), which we have filed a separate writ petition challenging that also. Now, my lords, in this case, the possession also has not been taken. The endorsement is given, my lords, by the authorities saying that possession is not taken. Award, my lords, has been passed, but neither deposited, no averment about what has happened to the award also, though we have not taken. That's why we have come here only on the ground that possession is not taken, that endorsement we have produced. Lords, along with our memo for production of documents.
What was the first preliminary notification? Writ petition copy could
My lords, the first preliminary notification was, my lords, under 4-1.
that is dated?
My lords, 14/10/1992, Annexure A, page 15, my lords.
Then final notification?
Final notification came on 28/3/1994, Annexure C, page 32.
Okay, 16/2.
Lord, 16/2, there is no notification at all of 16/2. That's our case, and there is an endorsement given. which
Possession
we-
not taken.
Possession is not taken, which is, in fact, this KSRTC itself seeks possession. And my lords, during the pendency of the writ petition,
Award not passed.
award is passed, my lords, but not deposited. Neither deposited in the treasury nor in the court. And there is no averment by the state so far as what award has happened. If your lordship kindly sees our memo for production of documents which we have filed now, my lord.
ಎಷ್ಟು ಎಕರೆ ಜಮೀನಿದು?
Lords, this is about. There are totally, my lords, 1, 2, 3, 4, 5, 6, about 6 items of property, my lords. 38 quintas, 31, 60, 13, 20. Lords, totally about 38 plus 30, 60, 80, 95, almost about 2 acres odd, my lords. Now, my lords, if your lordship kindly come to the memo which we just produced to your lordships, in that the endorsement your lordships would get. My lords, at 50, please come to 36, my lords.
Now, what has been upheld up to Supreme Court?
The acquisition, the initial, the 4-1 and 6-1 were upheld.
4-1 and 6-1 are upheld.
Upheld. That's why I said that was upheld. Now, my lords, I have come saying that since you have not, and because of 24-2, their amendment having come into force. Now, if you have not taken possession and if you have not deposited it also, both has to be satisfied. If that is the case, my lords, this acquisition now has to
Get a fresh cause of action.
That's
your
that's
contention.
the thing. We have set out everything in the thing. Please come to page 33. Endorsement given by the land acquisition officer himself saying that, my lords, the possession is still with us. As on 2021.
Just comment.
16-2 notification is not there. my lords.
Original. Award is passed or
ಅವ್ರ ಅವಾರ್ಡ್ ಆಗಿದೆ ಅಂತ ನಾವು ಹೇಳಿದೀವಿ, ನಾವೇ ಹಾಕಿದೀವಿ. There has been a
not available.
Because where does KDB come in?
lords,
You have a KDB.
ಅವರಿಲ್ಲ KDB ಅಲ್ಲ, ಇವರು KSRTC.
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 My lord, in this case,
Government, listen.
petitioners 1 to 3, one preliminary objection with regard to the maintainability of the writ petition. My lord, even according to the petitioners, my lord, the petitioners 1 to 3 were the owners of the property and they have sold the property to petitioners 4 and 5. My lord, so far as petitioners 4 and 5 are concerned, they cannot invoke section 24(2). The full bench decision of the Supreme Court is there, your lordships are aware. That is,
No, they are entitled to compensation, no?
No, my lords, I sell it when the acquisition was quashed.
Acquisition has
State
been
did not
upheld.
challenge it. My lords, the state did not challenge the quashing of the acquisition on my writ petition, which was allowed in the first instance. State did not challenge. It is KSRTC which challenged.
Yes.
By that time, the sale had taken place. So now, my lords, I will have to safeguard the entire interest.
No, the decision of the Supreme Court reported in 2009, volume 10 SCC 229. And that a subsequent purchaser.
Citation.
That overruling the earlier two bench decision of the Supreme Court. That this is what has been held. Para 8 of the judgment. Para 8, it has been laid down that the purchasers on any ground whatsoever cannot question proceedings for taking possession. A purchaser after section 4(1) notification does not acquire any right in the land as the sale is ab initio void and has no right to claim land under the policy. When we ponder as to beneficial provisions of section 2013 Act, they also intend to benefit landowners mentioned in the notification under section 4, not for the benefit of such purchasers who purchase the land after it has been vested in the state. Subsection 4 of section 11 of the Act, which is akin to section 4 of the 1894 Act, contains a prohibition that no person shall make any transaction or cause any transaction of land or create any encumbrance on land from the date of publication of such notification. Section 11(4) is extracted here and there. Then, my lord, I request your lordship to kindly go to para 19 and 20. Para 19. The 2013 Act presupposes that a person is required to be rehabilitated and resettled. Such a person who has purchased after section 4(1) notification as sale deed is void under section 1894 Act cannot claim rehabilitation and resettlement as per policy envisaged under the 2013 Act, as his land has not been acquired, but he has purchased a property which has already been acquired by the state government. He cannot claim even higher compensation as per proviso to section 24(2) under the 2013 Act. An original landowner cannot be deprived of higher value under 2013 Act, which higher compensation was not so contemplated when the void transaction of sale had been entered, and right is conferred under the proviso to section 24(2) on recorded owners under the 1894 Act. We have come across instances in which after notifications under section 4 were issued and the property was purchased at throwaway prices by the builders and unscrupulous persons, such purchasers are void and confer no right even to claim higher compensation under section 24(2) of the 2013 Act, as it is to be given to the owner as mentioned in the notification. Given that the transaction of sale effected after section 4 notification is void, is ineffective to transfer the land, such incumbents cannot invoke the provisions of section 24. As the sale transaction did not clothe them with the title when the purchase was made, they cannot claim possession and challenge the acquisition as having lapsed under section 24 by questioning the legality or regularity of proceedings of taking over possession under the 1894 Act. It would be unfair and profoundly unjust and against the policy of the law to permit such a person to claim resettlement or claim the land back as envisaged under 2013 Act, when he has not been deprived of his livelihood but is a purchaser under a void transaction. The outcome of exploitative tactics played upon poor farmers who were unable to defend themselves. Thus, under the provisions of section 24 of the Act, challenge to acquisition proceedings of the taking over of possession under the 1894 Act cannot be made based on a void transaction, nor declaration can be sought under section 24(2). But this has been followed in
Please see para 4 of my
other
pleadings.
cases also. I have
Para 4 in the writ petition you have stated. Their appeal was delayed appeal. By that time, since the accusation had been quashed, 1 to 3 had sold it in favor of 4 and 5. Then, my lords, their delayed appeal came to be allowed. That is how, my lords, it's not a question of sale after 4.
That is
sale was after the acquisition was quashed, and thereafter the acquisition was upheld. There is a slight difference.
This is one aspect.
But the government has to say, my lords,
and in the decision of Hindu Development Authority versus Manohar Lal, the Supreme Court has clearly held that if the acquisition has attained finality, yeah, it is concluded, my lord, in this case, it is concluded by the decision of the Supreme Court, then section 24(2) cannot be invoked under any circumstances. That is the decision of the Supreme Court in Indore Development.
So there are two aspects. to this.
Pardon?
There are two aspects to this.
Yes.
One, right of the subsequent purchaser to sue. Okay, see, you need to address the court. Here it's a bit of a change, there is a bit of a change circumstances in the sense acquisition was set aside.
That is.
So when there was no valid 4-1 notification, the property was purchased.
No, my lord, the date is not mentioned in the.
Okay, sir, listen, according to
Yes,
their
yes.
submission,
I will.
because government also has to get ready.
Yes.
See, when there was no valid 4-1 notification, the property was purchased. This you need to answer. Under the circumstances, can we consider that petitioner is petitioner has to be considered as a subsequent purchaser because of the change circumstances, number one. Number two, see, acquisition is complete only after possession is taken and amount compensation is awarded and amount is deposited.
Yes.
Okay. See, if preliminary and final notification takes place,
No, we have deposited the amount.
sir, listen, when preliminary and final notification takes place, there can be a challenge made to the acquisition. Okay.
Yes.
Final notification is upheld. There is nothing wrong in issuance of preliminary and final notification. That means to say the land is fit for acquisition.
Yes.
Okay. Preliminary notification is made, objections are called for, objections are made. Final notification is passed acquiring the land. That is challenged. Final notification is upheld. That means to say land is fit for acquisition. It ought not to have been left out from acquisition.
Yes.
Okay. But what happens thereafter? Possession is not taken. Compensation is not paid. The petitioner again gets a right to challenge it.
Yes. I understand.
Okay. So these are the two aspects that you need to address. One is when the purchase happened, according to the petitioners, 4-1 notification was not valid.
Yes.
Both the cost.
So that means to say, under those circumstances, can he be treated as a subsequent purchaser? Number one. Number two, if possession is not taken, if compensation is not deposited, or award is not passed, then in that event, even if the courts have upheld the final notification, can't he challenge the acquisition again on the ground of possession not having been taken and award not being passed and compensation not being deposited? Because the rationale behind the time frame fixed for completing the acquisition proceedings is once you deny the petitioner the right over his property, he has to be duly compensated.
Yes.
Okay.
Yes.
These two aspects you have to address.
Yes. In this case, award has been passed and we have deposited the amount also with the land acquisition officer. Well, that amount is with the land acquisition officer. Well, if that is there, then
Government has to say that.
government will have to produce the records, my lord. They are not-
Officer.
And
judgment
possession has been handed over to the KSRTC subsequently, my lord.
Possession has
I have-
been-
Yes, I have.
That is during the pendency of writ. If your lordship sees that letter, that is
have
either here.
Also look into this particular judgment.
I have produced the statement of objection.
The effect of AR 2023, workole. One judgment barkule. That may come to your rescue, I don't know.
Yes. Yeah.
Year 2023, Supreme Court 1964.
1964.
1964. Year 2023, SC 1964.
Yes.
Okay.
Yes.
Implication of this judgment on the present facts. Also, you look into it. Comment yavaga hakanappa?
2 weeks.
At the request of AGA colon. ಈ judgment ಇಟ್ಕೊಳ್ಳಿ. Two weeks between date ಕೊಡಿ. ಇಪ್ಪತ್ತು.
After 23rd, I will not be in the country till 21st.
23rd. 23rd.
Please.
Serial number 18. Number 18.
But this is a matter remanded from the Supreme Court.
In this matter, may I request, my lord, the main matter, my lord, what it has been remanded back from the Honorable Apex Court in Muralidhar's case has been finally heard by the coordinate bench of this Honorable Court, and it is reserved for the judgment, my lord, till the decision is taken in that matter. This may kindly be deferred, my lord, because that is the opinion of the Honorable Apex Court also, because the constitutional validity of section 17 and 20 was in question. And the same issue.
ಎಷ್ಟು ವಾರ ಅರ್ಜೆಂಟ್ ಮಾಡ್ಲಿ? ರಿಸರ್ವ್ ಆಗಿದೆಯಾ?
Reserve ಆಗಿದೆ. Justice Nagprasanna Sahibar ಮುಂದೆ hearing ಆಗಿ has been reserved, my lord.
Okay, when do you want it?
All that bunch of matters, same issue is there, my lord. That is subject.
Let it come out then. Yes, sir.
But this is a case where, my lords, earlier, the 300 times assessment, my lord, as compensation under section 20 of the Slum Clearance Board Act was, my lord, removed. And this honorable court, my lord, said compensation can only be under the Land Acquisition Act. Division bench also upheld it. Supreme Court said this rule was struck down without a pleading. Now the matter has been sent back, that the pleading should take place, then the matter has to be heard.
Yeah, when do you want it?
Your lordships are aware of it that Nagpur Improvement Trust 73, you may acquire under any statute, but you should pay the compensation under this act. His Lordship Justice Nariman also in that 2019, interpreting the latest act, even though under that sixth schedule, the national highways was excluded. He said you read the statute into.
Sir, I am also taking a similar view.
Yes, my lord, your lordships, I think.
My opinion is, whatever provision of law, whichever organization may acquire, ultimately, the state and agency of instrumentality.
Yes,
the state is
compensation
acquiring.
can only be under the Land Acquisition Act, now under 2000.
Deprivation of the use of land, the compensation has to be just fair and reasonable.
That's what it has been requested. I know.
Is it just fair and reasonable?
No, my lord.
So it has to be one compensation.
Yes, my lord.
Okay, in fact, BDA Act alone, a Supreme Court judgment is my hands are tied. We have to follow it. But my honest opinion on the matter is, acquisition is acquisition. Whichever enactment you do,
It's a losing of the land.
organization may acquire it. Ultimately, the loser of the land will have to be compensated equally. That's all.
But from 73, we have been denied. We sought for a mandamus, contempt.
Anyway, reserve agide the coordinate bench. Let us see.
That's why that decision is taken in that matter, squarely applicable to this case.
I
also,
will
my lord.
adjourn it by 2 weeks. Let us
Please, my lord.
the request of respondents call after 2 weeks. Carry on, Nisha. I'll just go on. 5 minutes, I'll come back.
19, Anil Kumar.
Respondent.
Mr. Pradeep Kumar.
Lord, this, Lord, this matter, Lord, 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 it is connected with Lord, WP 149-137.
ನಾಳೆ ಬರ್ತಾ ಇದೆಯಾ? The request of a respondent,
Serial number 19, my lord.
Yes, sir, 19, sir.
Please, my lord, I am for the petition, my lord.
Okay,
Your lordship was pleased to give date.
yeah, the council for respondent is submitting that connected matters are being posted tomorrow.
Please, madam.
So
Tomorrow,
we'll
my
call
lord.
it tomorrow.
Please, my lord.
The request of parties, call on another date today, list the matter along with WP number.
49-1037 of 2, 15, 49-804 of 15.
ಒಂದಾದ್ರೆ
One
ಸಾಕು.
number, sir. 49137 of 15.
Yes.
Tomorrow. 20, 21 adjourned. 22, SV Prakash, 22. Ildar Shirali.
Pass over ಮಾಡೋಣ. Pass over.
Twenty-three adjourned. 24, 25, 26 adjourned. 27, Nagaya.
Appear for the petition.
Sri Ram Krishna.
That's what has happened in this.
Display Thorsi.
Yes, 27.
Lord, I am not the party.
DDS.
Pass over ಮಾಡಲಾ?
Some other day.
Sir, BDA.
BDA ಇದ್ದಂಗೆ ಇಲ್ಲ ಅವ್ರ ಬಹುಶಃ.
Ramakrishna is not there for BDA. BDA na ಇದು?
BDA.
Against the BDM.
Panel ಇಲ್ಲ.
ಆಯ್ತು BDA ಚರಾಟಿ ಅವ್ರಿಗಾದ್ರು ಕೊಡು.
Murgeshwi Charati.
ನೋಡಿ ಅದು. ಎಷ್ಟನೇ ರೆಸ್ಪಾಂಡೆಂಟ್? 1 and 2 ಗ?
1 and 2, sir. Serial number 27.
So and so is directed to accept notice for respondent number 1 and 2. Call after 2 weeks. Objections if any by then ಅವ್ರಿಗೊಂದು ಸೆಟ್ ಕೊಟ್ಬಿಡಿಯಪ್ಪ.
Please, madam. Right.
28, Prakash, MH. Harish Kumar, MS.
Pass over.
29.
This is the fourth round litigation, Lord. There is already an order passed by this honorable court saying that petitioner is entitled to compensation if his private land has been utilized for school construction and road formation, my lord.
Lord, the matter.
There is already an order passed by this honorable court, my lord.
My lord, order passed by this honorable court to verify and pass an order. In respect of that, my lord, impugned order passed. Kindly see, my lord. Annexure, my lord. Annexure B. Annexure B said, my lord, the land is utilized in the year of 1967. And also petitioner family itself given voluntarily submit to the government to establishing the school and road is concerned. On that regard, my lord, the inquiry is made. And also, my lord, petitioner has not cooperated to the survey is concerned, my lord. And that has been recorded this court and reject the application. Now they challenging again this.
What remains?
Kindly see annexure A, my lord, page number 15, my lord. Order passed by this honorable court, my lord. He had given several representations saying that his land has been utilized for formation of page number 15, my lord, annexure A. Already decided by this honorable court, my lord. With this writ petition was disposed of, giving direction to the Deputy Commissioner Tumkur to hold an inquiry and find out whether his private land has been utilized. And my lord, it is forthcoming at page number 20, my lord, relevant direction. Your lordship may come to page number 19, my lord. There is a directions given by the High Court, Honorable High Court, my lord. The right of the above, writ petition is disposed of with the following directions.
Okay, pursuant to this, what happened?
Lord, inquiry was held, my lord, annexure B. The direction was, if his private land has been utilized, give him compensation, acquire him. And the Deputy Commissioner holds inquiry, my lord. And in the inquiry, page number C, kindly see page number 24, my lord. Relevant lines, I'll be drawing the court's attention only to the relevant lines, my lord. In 24, my lord, ಫಸ್ಟ್ ಪ್ಯಾರಾ 24 ಇವರ ಹೆಸರಿಗೆ ಸೋನ್ಸೋ ಎಕರೆ ಜಮೀನು ದಾಖಲಾಗಿರೋದು ಕಂಡು ಬಂದಿರುತ್ತದೆ. ಸರ್ವೆ ನಂಬರ್ 51 ಜಮೀನು ನಕಾಶೆ ಕಂಡ ದಾರಿ ಇರುವುದಿಲ್ಲ. ತಾಲೂಕ್ ಸರ್ವೇಯರ್ ಅವರ ತಯಾರಿಸಿರುವ ನಕ್ಷೆಯಲ್ಲಿ ತೋರಿಸಿರುವಂತೆ ಗೊಲ್ಲರಹಟ್ಟಿ ಮತ್ತು ಹರದಗೆರೆ ಬೋವಿ ಕಾಲೋನಿಗೆ ಓಡಾಡುವ ಕಾಲುದಾರಿ ಇದು ಡಾಂಬರೀಕರಣ ರಸ್ತೆ ಮಾಡುವ ಎಲ್ಲಿ ಕಟ್ಟಡವಿರುತ್ತದೆ ಎಂದು ವರದಿ ಸಲ್ಲಿಸಿರುತ್ತಾರೆ.
ತಾಲೂಕು ಸರ್ವೆಯವರ ನಕ್ಷೆ 51/1ರಲ್ಲಿ ಹಸಿರು ಬಣ್ಣದಿಂದ ಗುರುತಿಸಿರುವ 4 ಗುಂಟೆ ಪ್ರದೇಶವು ರಸ್ತೆ ಹಾಗೂ ಕಟ್ಟಡ ಇರುತ್ತದೆ ಪ್ರದೇಶವಾಗುತ್ತದೆ ಎಂದು ವರದಿಸಿರುತ್ತಾರೆ. Finding given my lord, in 4 guntas of land, road is formed, and in 2 guntas of land, school is constructed, my lord.
Before that, my lord, page number 23. sir.
ಅವ್ರು ಹೇಳದ್ಮೇಲೆ
Please.
ಮಾತಾಡ್ಯಾ? ಹಾ.
My lord, he is an illiterate person, my lord. But the finding is that, my lord, in 4 guntas, road is there, and in 2 guntas, my lord, school is there, my lord. And to overcome the order passed by this honorable court, my lord, the reasonings given by the deputy commissioner is forthcoming at page number 26, my lord. Lordship, may I request your lordship to see 26, my lord?
1 second, please.
Yes, my lord. Since this is in existence from last several years, ಮತ್ತೆ acquisition ಮಾಡೋ ಅಂತ ಅವಶ್ಯಕತೆ ಇರೋದಿಲ್ಲ. That was not the direction issued by this honorable court, my lord. If it is already there in his land, and if there are no proper acquisition proceedings initiated, acquire that land and give him the compensation for a poor farmer was the order passed by this honorable court, my lord. He sits over this matter, my lord, and page number 26, my lord, may I request, my lord? The deputy commissioner sits over the matter. Contrary to the directions issued by this honorable court, my lord. 3 ಗುಂಟೆ ಪ್ರದೇಶದಲ್ಲಿ ಶಾಲಾ ಕಟ್ಟಡ ಇರುವುದು ಈ ಹಿಂದೆ ನಿರ್ಮಾಣ ಮಾಡಿರೋದು ಅರ್ಜಿದಾರರು ಇತ್ತೀಚೆಗೆ ಅಳತೆ ಸಮಯದಲ್ಲಿ ಜಾಗದಲ್ಲಿ ಕಟ್ಟಡ ಇರುವುದು ಕಂಡು ಬರುತ್ತದೆ ಎಂದು ತಿಳಿಸಿರುತ್ತಾರೆ. ಈ ಜಾಗಕ್ಕೆ ಭೂ ಪರಿಹಾರ ಕೋರಿ ಅರ್ಜಿದಾರರು ಪೂರ್ವಿಕರು ಭೂ ಪರಿಹಾರ ಕೋರಿ ಅರ್ಜಿ ಸಲ್ಲಿಸಿಲ್ಲ ಹಾಗೂ ಕಟ್ಟಡ ನಿರ್ಮಾಣವಾಗುವ ಸಂದರ್ಭದಲ್ಲಿ ಯಾವುದೇ ಆಕ್ಷೇಪಣೆ ಸಹ ಸಲ್ಲಿಸಿರುವುದಿಲ್ಲ ಕಂಡು ಬಂದಿರುವುದಿಲ್ಲ. ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ಆದೇಶವನ್ನು ಸಹ ಪರಿಶೀಲಿಸಿದ್ದು ಪ್ರಾಸ್ತಾವಿಕ ಸರ್ಕಾರಿ ಶಾಲೆ ನಡೆಸುತ್ತಿರುವ ಕಟ್ಟಡ 3 ಗುಂಟೆ ಹಾಗೂ ಹಿಂದಿನಿಂದಲೂ ಇರುವ ಜೋಡಿ ರಸ್ತೆಯು ಸಾರ್ವಜನಿಕ ಬಹಳ ಹಿಂದಿನಿಂದಲೂ ಉಪಯೋಗಿಸುತ್ತಿರುವುದರಿಂದ ಈ ಜಮೀನು ಸ್ವಾಧೀನಪಡಿಸಿಕೊಳ್ಳುವ ಅವಶ್ಯಕತೆ ಕಂಡು ಬರುವುದಿಲ್ಲ. Lord, the specific direction was that, my lord, if it is there in his private land, and if his consent is not obtained, and if land acquisition proceedings are not initiated, acquire that land and give him the compensation was the specific direction issued by this honorable court, my lord. And this is also supported by the recent judgment of the honorable Supreme Court in Sukdat Ratra case, my lord, wherein the Supreme Court has said the government cannot take the plea of limitation to do justice, even if there is enormous delay. If a private land has been expropriated for public purpose, he has to be compensated, is the law, my lord. Unfortunately, my lord, this is the 5th round of litigation, my lord. ಆತ ಅಡಿಗೆ ಕೆಲಸ ಮಾಡ್ಕೊಂಡು ಜೀವನ ಸಾಗಿಸ್ತಾ ಇದ್ದಾನೆ. He is present before the court. 5ನೇ ರೌಂಡ್ litigation, my lord. The order denying compensation to this petitioner, my lord, was clear contempt of court, my lord. In fact, I even filed a contempt petition before this honorable court, my lord.
Lord, in respect of my lord, 23, page number 23. I rely on that only, my lord. 4ನೇ ಎದುರುದಾರರು ಉಪನಿರ್ದೇಶಕರು ಸಾರ್ವಜನಿಕ ಶಿಕ್ಷಣ ಇಲಾಖೆ ತುಮಕೂರು ಇವರು ಪ್ರಸ್ತಾಪಿತ ಗುಬ್ಬಿ ತಾಲೂಕು ನಿಟ್ಟೂರು ಹೋಬಳಿ ಹದಗೆರೆ ಗ್ರಾಮ ಸರ್ವೆ ನಂಬರ್ ಸೋ ಅರ್ಜಿದಾರ ತಂದೆ ಸ್ವೇಚ್ಛೆಯಿಂದ ಶಾಲೆಗೆ ದಾನ ನೀಡಿದ್ದು ಅವರ ಒಪ್ಪಿಗೆಯಿಂದಲೇ ಶಾಲಾ ಕಟ್ಟಡವನ್ನು ಕಟ್ಟಿದ್ದು ಮಕ್ಕಳ ಶೈಕ್ಷಣಿಕ ಹಿತದೃಷ್ಟಿಯಿಂದ 1957ನೇ ಇಸ್ವಿಯಿಂದ ಪ್ರಾರಂಭಗೊಂಡು ಇಂದಿನವರೆಗೂ ಶಾಲೆ ನಡೆದುಕೊಂಡು ಬರುತ್ತಿದೆ. ಸುಮಾರು 63 ವರ್ಷಗಳಿಂದ ಶಾಲೆಯ ಅನುಭವದಲ್ಲಿರುವ ಶಾಲಾ ಜಾಗವನ್ನು ಗ್ರಾಮಸ್ಥರು ಮತ್ತು ಗ್ರಾಮದ ಮಕ್ಕಳ ಶೈಕ್ಷಣಿಕ ಹಿತದೃಷ್ಟಿಯಿಂದ
ದಾಖಲೆ ತೋರಿಸಿ.
Please, my lord.
ದಾಖಲೆ ತೋರಿಸಿ.
My lord, on that regard, my lord, I want to file an objection on this point is concerned, whether my lord, given and other is my lord,
See, it might have happened in several ways.
please.
How it has happened, you narrate properly along with documents.
Please.
Okay, it may be a mere RTC change also.
Please.
like ಬೇರೆ ರೀತಿಯಲ್ಲಿ ನಡೀತಾ ಇತ್ತು.
ಅಲ್ಲ 67 ಅಂದ್ರೆ ಡಾಕ್ಯುಮೆಂಟ್ ಇರ್ಲಿಕ್ಕಿಲ್ಲ ಅಂತ ಅಮ್ಮವರು ಹೇಳ್ತಾರೆ.
ದಾನಪತ್ರ ಇರ್ಬೋದು.
Please. A measure was done in the presence of villagers, my lord. Officers had been there, my lord.
1967
Pass on
ಅಲ್ಲ.
this, my lord.
See, council, it is like this. See, your ancestors, it's not you acquired the property. You have inherited the property.
Yes, my lord.
Your ancestors were the owners of the property.
Yes, my lord.
See, your ancestors were the owners of the property.
Yes, my lord.
Now, supposing from 1967, the school building is in existence over there.
57 my lord. 1957.
1957, the school building is in existence over there. And the approach road is also formed and that is being utilized by the villagers. Then the question arises, how? You cannot probably claim compensation over it now. Okay.
No, my lord.
Anything over and above what is being used, if they try to fence it today, it's a different thing altogether.
Please.
Okay. Well, let's give some time to the government. Let the writ petition be kept pending. Let's find out what has happened.
Lord, my submission is that, my lord. In fact, pursuant to the direction issued by this honorable court, my lord, a detailed inquiry was held by the deputy commissioner, and the deputy commissioner had summoned all the concerned, my lord.
Let him file his
Education
application.
department.
Yes, so the request of AGA, call on date told,
I have it on my lord 23 month.
23rd.
And my lord, that Sukdat Ratra case, my lord, it specifically says, my lord.
Allah, in respect of that judgment is concerned, my lord, I have counted it. My lord, full bench of honorable apex court have clearly say that my lord, delay is very important role in the acquisition proceedings.
It's all right, you say.
Please.
File your objections.
30, Rajgopal Naidu, V. Vachan.
ಯಾವುದು?
Matter?
Lord, in this matter, I have filed.
Matter has been reassigned to me, my lord. By my lords, matter has been reassigned.
No.
I'll file my objections, my lord. There's already been orders passed by this honorable court giving certain directions to me, might have already been implemented, my lord. So I'll report back to your lordships what has been done. B. Vachan. BDA advocate.
PDA.
The request of the advocate for BDA, call on date told.
2 weeks, my lord.
Lord, no, last time also it had come kindly.
Yes, ಏನಾಗಿದೆ sir?
All right, yeah, will not unnecessarily.
ಅದೇ it is only seeking for direction for mandamus ಅಷ್ಟೇ ಬೇರೆ ಏನೂ ಇಲ್ಲ.
It's all right, you will find.
Past orders have been passed, my lord. There have been directions issued to
Call on
me.
date ಕೊಡಿ.
2 weeks, my lord. ಎರಡನೇ
But
ಮಂಡೇ.
in this first matter, my name may be shown instead of.
16th.
18-9,
Oblige, my lord.
18-9.
Oblige.
89, serial number 13 ನಲ್ಲಿ registry is directed to show the name of Sri Ashwatthappa D as the advocate appearing for the petition.
Oblige, my lord.
3.1 and 2 ನಲ್ಲಿ I have had an impleading application.
ಆಯ್ತು ಇರ್ಲಿ ಅವತ್ತು ಬರ್ಲಿ ನೋಡೋಣ.
31, Jayshima KP. A. Krishna.
The respondent appear for petition of my lordship. Writ of mandamus, my lord.
Krishna.
Annexure K, my lord, they are seeking for the consideration of annexure K, my lord.
Representation is for alternative sites, my lordship. The petitions are revenue site holders.
It may
They
be,
are sought
my lord,
for-
it may be disposed of in terms of the writ appeal passed in the Kempegoda layout is revenue site holders are concerned, certain directions are issued, my lord.
Binjuma case.
ಅಲ್ಲ ನಾಡಪ್ರಭು ಕೆಂಪೇಗೌಡ
ನಮ್ದೇ ಒಂದು ಆರ್ಡರ್ ಇದೆ ಸರ್.
ಅದನ್ನೇ
same.
Oblige.
ಇದು ತರ ditto. Disposed.
Oblige.
Disposed of. 32 adjourned, 33, Chandrasekhara, TA.
Here for the petition council, the last date of hearing, my learned friend was to file the statement of.
Yes, my lord, the objections is ready, my lord. Have it on next week, my lord. I will send to the website.
Down.
Next week, my lord, have it on, my lord, 12th.
I leave it to my lord. Because on that.
ಇಲ್ಲ,
day,
ಇಲ್ಲ,
the
ಆಗಿದೆ
language-
ಸ್ವಾಮಿ.
Because
This
it
could
is a
have-
pure question of law.
The request of AJ call on 12th.
12, 12.
Interim order may have to be extended.
Interim order ಇದ್ರೆ extend ಮಾಡಿ ನೋಡಿ.
Last time extend ಆಗಿದೆ.
ಆಗಿದೆ.
ಮುಂಚೆ ಇತ್ತಾ?
Plus.
ಅದಕ್ಕೂ ಮುಂಚೆ ಇತ್ತಾ?
ಅದಕ್ಕೂ ಮುಂಚೆ ಇತ್ತು.
ಆಯ್ತು, interim order granted earlier is extended till next date of hearing.
34, Abhijit, MM.
I appear for third response.
The writ of mandam for issue direction to the respondent number 2 and 3 to conduct the proper survey and erect the electric power line. They use the method of zigzag method, which is not in straight line. Seeking for a digital survey in that land.
Lord.
Provide some of the other property. They acquired my property.
Kindly see my representation, my lord. This already acquired the land.
That drawing of the attention line. That line has already.
But I am not putting to public
Awarded
quality,
compensation what that they are entitled.
but survey is not proper.
ಇದ್ರ ಮೇಲೆ ಬರ್ತದೆ.
It is not straight.
ಅವ್ರ ಕಂಟೆನ್ಷನ್ ಏನಪ್ಪಾ ಅಂದ್ರೆ ನೀವು ಹೈ ಟೆನ್ಷನ್ ವೈರ್ ಎಳಿಬೇಕಾದ್ರೆ ಸೀದಾ ಎಳೆಯೋ ಬದಲು ಕೆಲವ್ರಿಗೆ ಫೇವರ್ ಮಾಡಕ್ಕೋಸ್ಕರ
Yes, ma'am.
ಜಿಗ್ಜಾಗ್ ಆಗಿ ಎಳೆದಿ ಇವ್ರಿಗೆ ಅಷ್ಟೊಂದು ಇನ್ಫ್ಲೂಯೆನ್ಸ್ ಇಲ್ಲ, ಇವ್ರ ಲ್ಯಾಂಡ್ ಮೇಲೆ ಎಳೆದಿರ ಅಂತ.
That notification, their survey number has been mentioned. They notified the public. Notification, blood survey number has been mentioned
Telegraph Act, my lord.
under the Telegraph Act. But there is no deviation.
ಕರೆಕ್ಟ್. ಹಿಸ್ ಕಂಟೆನ್ಷನ್ ಈಸ್ ಅದನ್ನ ಎಳಿಬೇಕಾದ್ರೆ ಸೈಂಟಿಫಿಕ್ ಆಗಿ ನೀವು ಎಳೆದಿಲ್ಲ ಅಂತ. ಈಗ ಹೈ ಟೆನ್ಷನ್ ನೇರ ಹೋಗುತ್ತಲ್ಲಪ್ಪ.
Yes, yes.
Exactly.
That is the best way to put the high tension wire. ಇಲ್ಲಿ ನೀವು ಹಿಂಗಿಂಗ್ ಮಾಡಿದೀರಾ. ಯಾಕಪ್ಪ ಅಂದ್ರೆ ಅದ್ ನೇರ ಹೇಳಿದ್ರೆ ಒಬ್ರು ಇನ್ಫ್ಲೂಯೆನ್ಷಿಯಲ್ ಪರ್ಸನ್ ಜಮೀನ್ ಮೇಲೆ ಹೋಗುತ್ತೆ. ಅದಕ್ಕೋಸ್ಕರ ಜಾಸ್ತಿ ದುಡ್ಡು ಖರ್ಚು ಮಾಡಿ ನಿಮಗ್ ತೊಂದರೆ ಆದ್ರೂ ಪರವಾಗಿಲ್ಲ, ಸ್ವಲ್ಪ ಎಲೆಕ್ಟ್ರಿಸಿಟಿ ವೇಸ್ಟ್ ಆದ್ರೂ ಪರವಾಗಿಲ್ಲ, ಏನೋ ದೊಡ್ಡ ಮನುಷ್ಯರಿಗೆ ತೊಂದರೆ ಆಗ್ಬಾರ್ದು, ಇಂಥ ಬಡವರಿಗೆ ತೊಂದರೆ ಆದ್ರೂ ಪರವಾಗಿಲ್ಲ ಅಂತ ನೀವು ಅದನ್ನ ಮಾಡಿದೀರಾ ಅಂತ ಇವ್ರ ಆಪಾದನೆ.
Their representation will consider in accordance.
The time limit may be fixed.
That it is a representation,
under
but
the
instead
survey.
of directing
Digital
to me to
survey.
consider, let the second respondent has to consider the deputy commissioner, who is the competent authority, blood that where giving removal of obstructions has blood that even if it is.
ಎಲ್ಲಿದೆ ರೀ ಹೈ ಟೆನ್ಷನ್ ವೈರ್ ಇಲ್ಲ?
It to be started.
Yet to be started.
Work, deputy
Work
work
is
has been
started.
completed.
Tower was not inserted. Tower was not inserted yet.
The work has been completed, line has been completed, drawn. One tower and line has been drawn in this, their land. Let that diminution value has already awarded 1,32,434. The tower placement that compensation 17,330.
The case of the petitioner is that his land has been acquired by the authorities concerned for installing the high tension wire. High tension wire. Full stop. It is submitted that drawing of high tension wire in the locality has not been done properly and is not done in a properly, and is not done in a scientific manner. And is done in an unscientific manner. only because the respondents wanted to favor influential persons. Full stop. It is submitted if it were to be done if it were to be drawn in a scientific manner, then in that event, the lands of the petitioners would not have been required for drawing the high tension wire. Full stop. It is submitted in this regard. He has made a representation to respondent authorities to consider his case. Full stop. Next para. As the same has not been considered so far, the present writ petition is filed with the prayer to direct the respondent authorities.
Respondent number 3.
Consider his case.
Third respondent.
Respondent number 3 and direct the respondent number 3 to consider his case in accordance with law and pass appropriate orders. Full stop. Next para. The counsel for respondent number 3, upon instructions, submits that the high tension wire is proposed to be drawn in a scientific manner. Full stop. Nevertheless, he submits. They are open for considering the request of the petitioner and pass appropriate order in accordance with law. And he further submits that if it is found that the high tension wire has not been drawn scientifically,
If
the same would be rectified.
That cannot be, that there is an, in accordance with, that notification only, that survey number has been mentioned, that submission, that it accordance with will consider, but whether that it is find out that
Contention only, the survey is not in a proper way.
the survey has been conducted, revenue authority has been conducted. They have find out that we have the location also.
Hence the following order. Respondent number 3 is directed to consider the representation of the petitioner within a period of
2 weeks.
4 weeks.
4 weeks from the date of receipt of certified copy of this order and pass appropriate orders in accordance with law.
In suppose in wrong way,
They'll do something. Go.
adjourn. 36, P. Mahesha. Case B. Maya.
Number 3. Petitioner, looking for writ of mandamus, my lordship. Consider our application for damages by annexure B1 to B12.
Mahesh, you are absent. New answer. Where am I? Correct. You are absent in some
2003 notification.
My lordship, similar orders has been passed by annexure A, my lordship.
Equation allow ಆಗಿದೆ. Equation approve ಆಗಿದೆ. Consider. Consider.
Honorable Apex Court, my lordship. These matters, Honorable Apex Court in Karigowda's case, my lordship, it has directed to consider the application for, from the date of taking possession to the preliminary notification for damages.
ಅಲ್ಲ ಇದರಲ್ಲಿ ಕಾಂಪನ್ಸೇಷನ್ ಪೇ ಮಾಡಿಲ್ಲ ಅಂತ ಇದೆ. ಇಲ್ಲಿ ನೀವು ಹೈಯರ್ ಕಾಂಪನ್ಸೇಷನ್ ಕೇಳ್ತೀವಿ.
No. We are not seeking higher compensation. Damages from the date of taking possession to 4-1 notification. That's all, my lordship. We have already granted with the compensation, my lordship. What happened, my lordship? The reference court fixed 2,73,000. This honorable court enhanced it to 5 lakhs, my lordship, against which an appeal came to be filed before the apex court by the government, my lordship.
wherein, my lordship, it has been reduced. Compensation has been reduced only in respect of damages, my lordship, from the date of taking possession till the date of 4-1 notification.
ಯಾವುದು ಪೊಸಿಷನ್ ತಗೊಂಡ್ಮೇಲೆ 4-1
Yes, my lordship.
ಹೌದು.
ಪೊಸಿಷನ್ ತಗೊಂಡ್ಮೇಲೆ 4-1 ಆಯ್ತಾ?
19 submergence.
ಸಬ್ಮರ್ಜ್ ಆಯ್ತು.
Yes, my lordship. ಈ ಹೇಮಾವತಿ ಕೆನಾಲ್ ಅಪ್ಗ್ರೇಡ್ ಮಾಡಿದಾಗ
Case of the petitioners is that due to upgradation of Hemavati Canal.
Yes.
Hemavati Canal.
Tonnur Kere.
Tonnur Lake.
Tonnur Lake. Upgradation of Tonnur Lake, my lordship. Some water has been released from Hemavati Canal.
ಎಲ್ಲಿ ಹೇಳಿದಿರ ಅದನ್ನ?
Is submerged in the backwaters of Tonnur Lake, my lordship. The fourth paragraph ಅಲ್ಲಿ, fourth paragraph in my application annexure B at page number 33. my lord. ಇಲ್ಲ, ಅರ್ಜಿದಾರ ಸ್ವತ್ತು ಹೇಮಾವತಿ ಜಲಾಶಯ ನೀರು ತೊಣ್ಣೂರು ಕೆರೆ ಹಿನ್ನೀರಿಗೆ ಸೇರಿ ಬಂದಿದ್ದು. ಅದರ ನೀರಿನ ಮಟ್ಟ ಹೆಚ್ಚಾದ್ರಿಂದ 1993.
The case of the petitioners is that due to certain developments in irrigation infrastructure. ಎಲ್ಲಾದ್ರೂ ಇಸ್ಕೊಳ್ಳಿ ಬಿಡಿ. Due to certain developments in irrigation infrastructure done by the state. The due to done by the state through third respondent organization. Correct?
Yes, Penny.
Third respondent organization.
Company. Yes.
The
petitioner's land has been
land of the petitioners got submerged in
ತೊಣ್ಣೂರು ಕೆರೆ.
Submerged in, sorry, got submerged. Full stop. After realizing the same, the state initiated acquisition proceedings and has paid compensation to the petitioners. Full stop. It is submitted that petitioners are also entitled to damages from the date of submergence of the land till issuance of notification under section 4 clause 1, 4-1 tana? 4-1 of the Land Acquisition Act, which has not been done so far. Full stop. Hence, the petitioners made a representation to respondent number 3 to assess the damages and pay them compensation. Full stop. As the same has not been done, the present writ petition is filed with the prayer to direct respondent number 3 to do the needful.
Not only respondent number 3, my lord.
1 and 2 are
1 and 2 also.
as competent authority land.
Special land acquisition officer has to.
1 and 2.
1 and 2.
Respondent number 1 and 3,
They have
1 to
to
3 and 1 to 3.
Assess the damage, then later on we have to pay.
To do the needful. Full stop. Next para. It is further submitted that under similar circumstances, this court as well as the Honorable Appeals Court has ordered accordingly. Has ordered accordingly.
Para 3 of the petition ಹೇಳಿದೆ.
ಅದನ್ನ ಅಲ್ಲೇ ಸೇರಿಸ್ಬಿಡಿ. Next para ಏನ್ ಬೇಡ. Previous paraದಲ್ಲೇ ಸೇರಿಸ್ಬಿಡಿ. Ordered accordingly. Full stop. Next para. The aforementioned submission of the petitioner is not contravened by the learned AGA or the advocate appearing for
Respondent number 3.
Respondent number 3. Full stop. They together submit the respondent number 1 to 3 shall consider the request of the petitioner and do the needful in accordance with law. Full stop. Hence the following order. Respondents 1, 2, 3 are directed to consider the case of the petitioner in accordance with law and pass appropriate orders within a period of
3 months.
ನೀವ್ ಹೇಳ್ಬೇಕು.
8 weeks, my lord. 8 weeks. 8 weeks.
8 weeks.
No, first part is second respondent has to determine the compensation.
ಅದಕ್ಕೇನಪ್ಪ ಟೋಟಲ್ ಎಷ್ಟು ತಗೊಂತೀರಾ ಹೇಳಿ.
4 months.
All of you are state.
4 months.
4 months.
ಏನ್ ಬಂತ ಹೇಳಿ? Pass appropriate orders and do the needful within a period of 4 months from the date of receipt of certified copy of this order. Yes.
37, Leela Raju MN.
Bring for the petition.
My lord, in the
For the respondent.
Uh, the
Lord, on the
pre-
last occasion, your lordship said directed to check as to what will be the rate that the BDA would be willing to offer. Lord, here, with regard to the marginal land, this one, Lord. BDM, Lord, I was informed that the BDA cannot reduce the cost for one person.
My lord, the matter in which few very important aspects has to be brought to the honorable court's notice.
So you will decide on merits.
Please.
My lord, here
You're ready to argue?
I am ready to argue.
Go on.
My lord, in the previous hearing also, has been heard in length by your lordship. My lord, in addition to that, I'll bring up to very specific.
First in the ಹೇಳಿ ನಮಗೆ ಮರ್ತೋಗಿದೆ.
My lord, this marginal land, this property in dispute is regarding a marginal land, my lord. That is annexed to a site which was originally allotted to my predecessor in title in 1975 to lease and sale agreement. In subsequent, in 2021, it was registered into my predecessor in title. I have purchased this property in 2013. My lord, the property in question in subsequent to the rest petition and the previous writ petition also, well, the marginal land is annexed to the western end of my land. Well, that is so attached to my property that other than me, no other person can
Okay,
utilize
one
that.
second, wait. Show me the order in 43796 of
My lord, if I may pursue your lordship to page number 35. Would read out the.
One second, wait. No position of the representative of the.
My lord, in subsequent to this. Yes, yes. Sorry.
Yes, have you filed an appeal on the order of this 43796 of 2018?
No, Lord.
Then you are bound by this.
Lord, I'm bound by this, but what is now sought to be asked, Lordship may kindly see annexure J, the endorsement what I have issued to him.
Listen.
Yes.
Read para number 4 and onwards in the writ petition.
Yes,
it makes it very clear
yes,
that BDA is required to allot the marginal land
please,
as per the rate prevailing in the year 2012 when he
Please.
made the application.
please.
You allot him accordingly. Otherwise, you should have gone and appeal
Yes.
on this judgment.
Yes, but
Yes.
what is now sought is, in spite of this order, my lord, lordship may kindly take annexure J, my lord.
Ah.
In spite of this order being passed by this honorable court, what is sought? Lordship may kindly see, my lord, I may permit it to read the entire endorsement which I have issued.
Where is it?
I would
Annexure
clarify on
J,
that point. I
page
would clarify
40.
that point, my
ಹಿಂಬರಹ
lord.
ಹೌದು ಮೇಲ್ಕಂಡ
Page
ವಿಷಯಕ್ಕೆ
40.
ಸಂಬಂಧಿಸಿದಂತೆ
ಪ್ಲೀಸ್. ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಹಿಂದಿನ CITB ವತಿಯಿಂದ ಬನ್ನೇರುಘಟ್ಟ ಬಡಾವಣೆಯಲ್ಲಿ ಇನ್ಶೂರೆನ್ಸ್ ಅಳತೆ ನಿವೇಶನ ಸಂಖ್ಯೆ 46 ಶ್ರೀ DS ಪ್ರಭುದೇವ ಎಂಬುವರಿಗೆ ಹಂಚಿಕೆ ಮಾಡಿದ್ದು ದಿನಾಂಕ 10/9/2001 ಶುದ್ಧ ಕ್ರಯಪತ್ರ ನೋಂದಾಯಿಸಿ ನೀಡಲಾಗಿದೆ. ನಂತರ ದಿವಂಗತ ಹಂಚಿಕೆದಾರರು ವಾರಸುದಾರರಿಂದ ಸದರಿ ನಿವೇಶನವನ್ನು ದಿನಾಂಕ 16/2/2013 ಕ್ರಯ ಪಡೆದಿರುವ ಶ್ರೀಮತಿ ಸ್ಮಿತಾ ಗುಬ್ಬಿ ಮತ್ತು ರವೀಂದ್ರ ಗಂಗಾ ಅವರ GPAದಾರರನ್ನಲಾದ GN ಸುರೇಂದ್ರ ಗುಪ್ತಾ ಎಂಬುವರು 24/1/2018 ಪ್ರಾಧಿಕಾರಕ್ಕೆ ಮನವಿ ಸಲ್ಲಿಸಿ ನಿವೇಶನಕ್ಕೆ ಹೊಂದಿಕೊಂಡಂತೆ ಲಭ್ಯವಿರುವ ಹೆಚ್ಚುವರಿ ಜಾಗವನ್ನು ಹಳೆಯ ಹಂಚಿಕೆ ದರವನ್ನು ವಿಧಿಸಿ ಹಂಚಿಕೆ ಮಾಡಿರುವಂತೆ ಕೋರುತ್ತೇನೆ. ಪ್ರಾಧಿಕಾರದಲ್ಲಿ ಪ್ರಚಲಿತವಾಗಿ ಚಾಲ್ತಿಯಲ್ಲಿರುವಂತೆ ಸೋ ಚದರ ಮೀಟರ್ ಹಂಚಿನ ಜಾಗಕ್ಕೆ ಮಾರ್ಗಸೂಚಿ ದರ ಪ್ರತಿ ಚದರ ಮೀಟರ್ಗೆ ರೂಪಾಯಿ 91,200 ಒಟ್ಟು ಸೋನ್ಸೋಗಳು ಪಾವತಿಸುವಂತೆ 11/2/2017 ಹಿಂಬರಹ
ಅಲ್ಲಪ್ಪ
ಅಲ್ಲ ಮುಂದೆ ನೋಡಿ ಅಲ್ಲ ಮುಂದೆ again he comes back to BDA and says no I'm not going to pay it at 2012 rate also. He
No,
wants
my
it
lord.
at 1975 rate.
The actual matter
Let me
in
complete,
right,
sir.
the honorable-
Let me complete.
Yes.
Let's not interfere. I'm not coming in the
Yeah,
way
it's
of
the whole
anything.
thing.
My
Yes,
lord,
my lord. He says again I should be given an opportunity of 1975 rate only.
no, my lord, as per
That
the
is what
instructions
has
of-
been
as per
rejected.
the direction of the Honorable High Court, I have made a representation in 29/10/2021 within 30 days as per the direction of the Honorable Court. And that is the only representation that I have made.
Lord,
They have
he-
come up with some other date of representation is 4/7/2022. Even at this date, I am ready to accept the rate as per of 2012. And they have,
See, come to page number 39,
Yes.
his representation.
I have
Therefore,
made
the
a
applicants request this authority to consider their representation and fix rate above the marginal site allotted as above on par with rates prevailing at the time of application for allotment dated 14/8/2013.
I have the original representation made before the BDA, my lord. I have the copy of the original
See,
representation.
the
made.
problem comes to you because you slept over and you have not challenged the earlier order.
Yes.
Okay, now show me your sale deed.
My lord,
Show me your sale deed if you have filed it.
Sale deed
sale deed, it is in
2000.
annexure A only.
Actually,
Yes,
yeah.
ma'am. Annexure A is my sale deed. It was bought in 19/12/2013 from my predecessor in title. My
Right, that-
predecessor title was the original allotted to the land.
GPA, annexure B is the sale deed, my lordship may kindly see this.
The GPA, sorry, ma'am.
Where have you mentioned about marginal land in this?
Here nothing is there.
My lord, in the sale deed, the property was not allotted to my predecessor in title. Hence, that predecessor in title cannot execute a sale deed on that marginal land. Hence, the representation has been made in 2012 itself by the predecessor in title. In subsequent to the purchase in 2013, I made a fresh representation. Despite that, they passed an endorsement in 17, my lord. And after that, I've sought a writ
Yes, you are
petition.
bound to allot it as per 2013 rate.
Lordship may kindly see the schedule which is at page 23 of the sale deed. Lordship may nowhere it is. It is marginal land will
what,
come.
my lord, I'm saying.
It will not come. Marginal land is not shown as a property abutting to his mainland.
Doesn't matter, he makes a fresh representation. And you suffer the order at the hands of this court.
Yes,
See, he makes a fresh representation after the purchase, na?
yes. He makes a fresh representation after the
He
purchase.
makes a fresh representation after the purchase. Though it's allotted in 1975 to his predecessor,
Yes.
he makes a fresh representation in 2013.
Yes.
Then you suffer an order at the hands of this court in 2021.
He purchases it before the sale deed could be executed.
Look, Mr. Murugesh,
Sorry, yes. The sale deed is executed in favor of an allottee in the year 2018, not in the, not 2000.
The document surely indicates 2013. And
His sale deed. His sale deed.
yes, my lord,
Here,
in 2013, I purchased the property.
Before-
My lord, the first representation sought is with my predecessor in title itself.
2013 ಅಲ್ಲಿ ಸೇಲ್ ಆಗಿರ್ಲಿಲ್ವಾ?
that is what this endorsement says.
The endorsement says that in 2018, they issued an endorsement that I will allot the land to you. And my lord, with that endorsement, I have appealed, I have challenged it before this honorable court. And the honorable court has directed them to allot me the property as per 2013. I have made the representation as per the directions of this honorable court itself. They have not sought my
When did
representation.
BDA execute sale deed to your predecessor in title?
My lord, in 2002, my lord, 2001, 2. In 2001 itself, in lease cum sale agreement in 1975. And sale deed was executed in his favor in 2001, my lord, in predecessor in title. He was in complete possession then. And then I purchased the property in 2013.
You purchased the property
Yes, my
in
lord, from him.
2013.
He is not in acquisition of the property, so he can't execute the sale deed in my behalf. Then only representation has been made to allot the property. And BD has agreed to that effect and made an endorsement stating that, yes, I will allot the property to you. But that what I am aggrieved here is, I made representation in 1 year. They pass an order after 5 years, and they ask me to pay the marginal land valuation
Land-
as per after 5 years of market value.
So marginal land ವಿಸ್ತೀರ್ಣ ಎಷ್ಟಿದೆ?
My lord, it is approximately 1,000 square feet, my lord. It is annexed to my property. I would produce a document before this honorable court indicating the photographs of the marginal land. My lord, despite me, my lord, no other person can access the property. That is my backyard. From my end, by behind of my property, that is a private property.
This is a 40-60 site, huh?
Yes,
Mine is a 40-60 site, my lord.
his is a 40-60 site and the 928 square feet.
Now,
is
how
the-
do you overcome the judgment of this court? Tell me.
Lord, what has been said, if Lordship may permit me to read the order passed in the earlier writ petition. Lordship may
Read
kindly-
para 4 of the writ petition.
Yes. Then at the end, Lord,
Read para 4 of the writ petition.
having heard the learned counsel for the petitioner and perusal of the writ petition paper, it is clear that on an application dated 14/8/2012, the petitioners were intimated to pay a sum of rupees so and so being the value of the marginal site under Lord 14/8/2012, Lord, is a application for allotment of a marginal
What has
land.
been submitted before this court?
Sir, he tells it.
Read, ಪೂರ್ತಿ ಓದಿ.
And he purchases it in 2013.
Doesn't
Yes.
matter.
The petitioner application for allotment of a marginal site, even though was submitted in the year 2012, the same was considered by the BDA in the year 2017. If the application of the petitioners for the grant of a marginal site was considered within a reasonable time for the date of submitting the application, that is in the year 2012, the petitioners were required to pay the land value prevailing in the year 2012. The manner and the method of calculating the value of the marginal land would have to be considered as on the date of the petitioner's application. If the respondent BDA considers the application belatedly, the petitioners cannot be held responsible for paying high value for the marginal site. In the instant case, having allotted the marginal land as per the endorsement dated 11/12/2017, the respondent BDA was required to take note of the date of the application of the petitioner. Under Annexure G, the petitioner requested for recalculating the value of the site, taking note of the original allotment made in the year 1975. The request of the petitioner to allot a marginal site, taking note of the price of 1975, would be unreasonable. The learned counsel for the petitioner submit that the petitioner would make one more representation requesting the BDA to recalculate and collect the value of the marginal site as on the date of the application. Hence the following. The petitioners are permitted to submit a fresh representation within 30 days from the receipt of copy of this order. If such representation is made by the petitioner, the respondent BDA to consider the same along with the Annexure G dated 24/1/2018 and pass appropriate order in accordance with law.
My lord, a point
Now,
may be.
the Annexure J, which is before your lordships, is an intimation to him pursuant to the order passed by this honorable court. It's specifically observed, you have again,
Okay,
sought-
justify that.
again, you have, that is not under challenge.
They're
also.
claiming that
He did
I'm
not
asking
challenge
him
this.
marginal allotment
Sorry.
of property.
He is not
What?
he is not challenged Annexure J also.
My lord, I have
What does
clearly
this
asked
mean?
it.
He is just asking for a mandamus.
We will set aside, we'll mold the relief.
Another part of my prayer, I'm seeking honorable court to pass any other orders as the honorable court may deem fit also, my lord.
Lord,
The
this
discretion
person
power of
makes
this
an
honorable court.
application.
And my
Yes.
lord, here the endorsement that
There
they
is
have
proper
issued.
amendment to your writ petition. You have to challenge Annexure J, no?
Yes, my lord, I'll challenge the annexure J.
The request of petitioner call out for 2 weeks. Do what you.
Lord, a date may be granted, my lord.
ಏನ್ ಡೇಟ್ ಮೇ ಬಿ ಗ್ರಾಂಟೆಡ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕ್ಬಿಟ್ಟು ಮೂವ್ ಮಾಡಿ ಬರುತ್ತೆ.
Yes, my lord.
28, Vinod Gowda.
But here in this case, not case.
See, in the meanwhile ನೀವು ಅದನ್ನ ಅಪೀಲ್ ಹಾಕಂಗಿದ್ರೆ ಅಪೀಲ್ ಹಾಕೊಳ್ಳಿ.
Please.
ಯಾವ್ದು?
ಹಳೆ order. ಹಳೆ order.
ಹಳೆ ಆರ್ಡರ್. That is left to you. See.
Yes, I understand.
Para number 4 is binding on you.
Yes.
You can't overcome that. It's binding on you,
Binding
it's
on-
staring
yes,
at
no.
you.
Yes, no. The first portion of para 4 is
That
clear.
is the ratio.
Yes, no.
That is the ratio on which it is decided. Do what you want.
Yes.
I have not advised anything. Do, both of you do what you want.
Yes.
My lord, I am ready even to, as per the state to, if they allot the property, if we come to violation of 2012 side, I am ready to
Look,
pay.
mister, when you file a writ petition, should you not file it properly?
My lord, I was seeking as.
When there is an order passed against you, where is the question of granting mandamus unless that order is set aside? You understood, no?
Yes, my lord,
Then
I'll make an amendment to the.
do what you want. We don't know.
38, Vinod Gowda.
That's all, sir.
In this case, here, petitioner land here, the petitioner land was acquired.
Court has not suggested anything, okay?
Yes.
ಹೇಳಿಯಪ್ಪ.
Here petitioner land was acquired for the formation of the road by the BDA. Here petitioner grandfather acquired property of an extent of 4 acre 8 guntas in survey number 100/1 of Kannali village. In that, here the petitioner got 1 acre 30 gunta through partition. He was in possession of 1 acre 30 gunta. Now the BDA has acquired full 1 acre 30 guntas land. Only they had issued a notice to my uncle and my grandfather, who is no more. They had not issued notice to me.
Were
Or
you,
paid a
did your name find a place in revenue records?
Yes, ma'am. I have produced the revenue record. I have produced the compromise petition also. You do. Subsequent to acquisition, there is a compromise petition which is filed. And Lord, he claims the compromise petition is set to
Preliminary notification ಯಾವಾಗಿದೆ ಅದು? ಆಯ್ತಪ್ಪ.
2005. My mother name was page number 10 ಅಲ್ಲಿ ಪಾಣಿ.
Sir, 2005 ಅಲ್ಲಿ ಯಾರ ಹೆಸರು ಬರ್ತಿದ್ರಿ ಪಾಣಿ?
I produced RTC, page number 10. My mother name was there. My father was no more.
ನಿಮ್ಮ ಹೆಸರಲ್ಲಿ
ಮನಿಯಮ್ಮ. ನಮ್ಮ ಹೆಸರು ಗೋವಿಂದರಾಜು. My mother was, I was minor at that time.
ಮತ್ತೆ
Mother ಹೆಸರು
the
ಮುನಿಯಮ್ಮ.
question of issuing any notice to you. ಏನಾಗ್ಬೇಕು ಇವಾಗ?
They had acquired 1 acre 30 gunta. Let them survey the land and let them pay the compensation. But what has happened is, sorry, he claims by virtue of OS number 623 of 2014, the compromise decree has been drawn by the civil court. But there's one more, Mr. Badraya. He has challenged.
What have you done?
They have challenged this.
What have you done with regard to?
We have acquired the property. We have taken possession. They have no dispute with regard to that. With regard to identity.
Compensation, what you have done?
Compensation with regard to civil suit pendency of civil court, my lord, we have not done anything.
Why are you not required to deposit before the reference
But
court?
there is a stay of the decree passed in 623 of 2014 is filed by he's also a party to it. No, may I pass on this?
Yes, could it, what does it say?
Now they had. ಯಾರ್ದು compensation ಕೊಡಬೇಡಿ ಅಂತ ಹೇಳಿ ಒಂದು stay ಇದನ್ನ ತಗೊಂಡಿದ್ರು.
What does the order say?
ಅಲ್ಲಲ್ಲ ಅದು 4 acre 8 guntas ಇರೋದು. They are in different non-possession ಇರೋದು. They had taken they are.
So where is the operative portion of the order?
Well, that is, we had to get that. I got.
I mean, you pass and you pass the award and deposit before the reference court. Let them prove their title and whoever is the owner, they will take it.
Yes. Non-possession ಇರೋದು they had taken.
Whatever. ಬನ್ನಿ.
Our possession ಇರೋದು ಹಂಗೆ.
Annexure G ಏನ್ ನಿಮ್ದು? What is annexure G?
A representation given.
ಏನ್ representation ಕೊಟ್ಟಿದ್ದೀರಾ?
To do the survey. But in that page 34 may kindly be seen.
ಬನ್ನಿ. The case of the petitioner is certain lands belonging to him has been acquired by the BDA, respondent BDA. Full stop. Huh? Hence, he has submitted a representation to allot alternative sites to him in lieu of the acquisition of his land. Full stop. Next para.
And also do the survey.
That's not required. The next para. The counsel for respondent submits that the land which is the subject matter of the writ petition has been acquired by BDA. Full stop. But he contends that there is a dispute as to ownership of the lands concerned. Huh? Full stop. He further submits as there is a dispute with regard to ownership, compensation has not been paid to the parties. Huh? Full stop. Next para. Once lands have been acquired, the acquiring authority is duty bound to pay compensation to the owners concerned. Full stop. If there is any dispute with regard to ownership, then a reference is required to be made and the compensation is required to be deposited before the reference court, and it is for the respondent and it is for the rival claimants to make necessary application before the reference court and seek release of the compensation. Full stop. Hence the following order. Respondent is directed to pass necessary award in respect of the land, which is the subject matter of writ petition, and deposit the compensation before the reference court in accordance with law. Full stop. Liberty is given to the petitioner and such other persons who are interested in the land to make necessary claim in respect of the compensation. Yes.
My lord, resurvey, I asked to resurvey.
Writ petition is disposed of accordingly. Yes.
ಅಲ್ಲ resurvey ಜಾಸ್ತಿ ತಗೊಂಡ್ಬಿಟ್ಟಿದ್ದಾರೆ ಲ್ಯಾಂಡ್.
ಜಾಸ್ತಿ ತಗೊಂಡ್ರೆ ಜಾಸ್ತಿ ಕೊಡ್ತಾರೆ ಬಿಡಿ.
ಅಲ್ಲ ಒಂದು ವರ್ಡ್ resurvey ಮಾಡ್ಲಿಕ್ಕೆ ಒಂದು.
ಏನ್ resurvey?
ಅಲ್ಲ actually 1 acre 1 gunta they had given notice to my grandfather. Now they had taken 1 acre 30 guntas.
It is needless to state if ಜಾಸ್ತಿ ತಗೊಂಡಿದಾರಾ?
ಹೌದು ಜಾಸ್ತಿ. ಕೆಂಪೇಗೌಡಗೂ adjacent acquisition
ಆಯ್ತು. It is needless to state that if the land acquired is more than ಮೊದಲಿಂದ ಮಾಡ್ತೀನಿ ಕೊಡ್ರಿ ಇಲ್ಲಿ ಬರ್ರಿ ಇಲ್ಲಿ ಎಲ್ಲ ಕ್ಯಾನ್ಸಲ್ ಮಾಡಿ. The case of the petitioner is that he is the owner of
property 1 acre 30 guntas.
1 acre 30 guntas of land in
survey number 100/1 Kannahalli village.
Of Kannahalli village. Huh? Full stop. He submits that 1 acre ಎಷ್ಟು acquire ಆಗಿದೆ?
30 guntas was acquired. Actually they had given notice for 1 acre 1 guntas. 1
acre 1 gunta of the said land has been acquired. Huh? Full stop. It is further submitted acquired admala it is further submitted but respondent BDA has taken possession of the entire land concerned. Huh? Full stop. Entire land concerned. Full stop. It is further submitted. No compensation has been paid to him for acquiring the said land. ಎಷ್ಟು acquire ಮಾಡಿದಿರಾ? ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದೀರಾ compensation?
1 acre 10 guntas is acquired for peripheral ring road and adjacent land is acquired. Same land is acquired for remaining extent is acquired for.
That is the preliminary notification and final notification.
Not a Prabhu Kempegowda.
Total is 1 acre 30 guntas you have acquired.
Yes. Yes.
Huh?
Yes.
You have acquired total.
Yes, no. They themselves say about all these things in their representations.
Next per contra, the counsel for respondent BDA submits that entire 1 acre 30 guntas of land has been acquired. Huh?
Yes.
In brackets 1 acre 10 guntas towards peripheral ring road and 20 guntas towards
No, not a Prabhu Kempegowda.
not a Prabhu Kempegowda layout. Huh? Full stop. He further submits as there is a dispute with regard to ownership of the lands concerned, compensation has not been paid to anybody. Full stop. Next para. In the incident petition, the petitioner has not challenged the acquisition of land, nor there is a prayer made in respect of 20 guntas of land which he alleges that has not been acquired. Huh? Full stop. However, respondent BDA is expected to act in accordance with law. Huh? Act in accordance with law. In accordance with law. Full stop. They are required to deposit the lands, the compensation before the reference court if there is a dispute as to ownership. Full stop. Dispute as to ownership cannot be a ground for BDA not to deposit the compensation. Full stop. Huh? ಇದರಲ್ಲಿದೆ notifications.
Notification. I will give the award copies.
Full stop. Next para.
Notification.
Regarding the extent of regarding extent of land acquired, if the petitioner has any dispute regarding the same, cancel. In the course of the proceedings, the petitioner further submits that he may be given the liberty to make appropriate representation to the respondent authorities regarding showing as to the extent of land that is actually acquired, and if any such ಅಥವಾ ಅದೊಂದು ಕೆಲಸ ಮಾಡ್ರಿ ಸ್ಕ್ರಾಚ್ ಮಾಡ್ರಿ ಎಲ್ಲ ಇತ್ತಂತ ತೋರ್ಸಿ will decide here itself. It will benefit you.
Please, I shall get one. I shall get.
Get the notification.
I'll get both.
ಈ ರೀತಿ ಮಾಡ್ಕೊಳ್ಳಿ. The case of the petitioner is that lands have been his lands measuring 1 acre 10 guntas have been acquired, but BDA has taken possession of entire 1 acre 30 guntas of land. Huh? Full stop. The counsel for BDA disputes the same and submits that entire 1 acre 30 guntas of land have been acquired. Full stop. In this regard, the counsel for BDA is directed to produce the notifications regarding the lands concerned. Regarding the lands concerned which have been acquired by next date of hearing. Call on. 10.
Please.
ಯಾವ್ದು ರಿಲೀಫ್ ಕೊಡ್ಸಕ್ಕಾದ್ರೆ ಕೊಡ್ಸೋಣ. ನೀವು ಸರಿಯಾಗಿ ಮಾಡಿಲ್ಲ ಅಂದ್ರೆ.
ಇಲ್ಲ ಮಾಡಿದೀವಿ ಅವರು ಅವರ ಸಂಬಂಧಿರದು ಎಲ್ಲ ಇಲ್ಲ ಅವ್ರು
ದಟ್ ಈಸ್ ಸೆಕೆಂಡರಿ. ನಿಮ್ಮ ಅಕ್ವಿಸಿಷನ್ ಕರೆಕ್ಟ್ ಇದೆಯಾ ನೋಡಿ ಫಸ್ಟ್.
ಇಲ್ಲ ಅದು 4 acre ಇರೋದು 1 acre 30 ಗುಂಟ ದೇ ಹ್ಯಾಡ್ ಅಕ್ವೈರ್ ಮೈ ಲ್ಯಾಂಡ್. ಅದು ಅರಕನೆಟ್ ಪ್ಲಾಂಟ್ ಎಲ್ಲ ಡೆಮಾಲಿಷ್ ಮಾಡಿದ್ದಾರೆ ಮೊನ್ನೆ ಜನವರಿಲಿ. ಐ ಹ್ಯಾಡ್ ಗಿವನ್ ಕಂಪ್ಲೇಂಟ್ ಫೋಟೋಗ್ರಾಫ್ಸ್ ಆಲ್ಸೋ.
ಇವಾಗ ಅಕ್ವೈರ್ ಮಾಡಿರೋದು 1 acre 1 ಗುಂಟ.
1 acre 30 ಗುಂಟಾಸ್ನೇ ಅಕ್ವೈರ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ.
ತಗೊಂಡಿದ್ದಾರೆ ಪೊಸಿಷನ್
ತಗೊಂಡ್ಬಿಟ್ಟಿದ್ದಾರೆ.
ಆಯ್ತು ಕೊಡಿ. 39 ಸುರೇಶ್ ಬಾಬು.
An extent of 700 square feet was utilized for formation of the 100-foot road, my lord. And I am entitled for an alternative site or an compensation to that, my lord. My lord, may kindly turn to Annexure F. There is a recommendations, my lord, at page 28.
Notifications ಇದೆ ತಾನ?
Notification in Manila, illegally utilized that land. So there is a recommendation to allot me 193 square feet. So I'm accepting it. In pursuance of the recommendation, there is no other steps taken. That is why I've sought for mandamus, directing them to at least to honor the recommendations what it has been made by the committee. Annexure F.
My lords, as per the committee direction, my lords, BDA, what steps has been taken? I have sought for instruction, my lord.
Are you disputing the committee recommendation? You can't.
No, they can't, my lord, even annexure E and F, both says that they have utilized 700 square feet illegally, that is without acquisition proceedings, unauthorizedly, they have utilized 700 square feet in formation of the 100-feet road.
Yes.
There's no dispute that I am the owner.
For the committee.
You don't dispute the existence of annexure F? Or is it bogus?
No, my lord, I am not disputing that, my
You're
lord.
not disputing, no? Then we'll pass orders. Yes, Bane.
In accordance.
The
with
case of the
multiple-
petitioners is that 700 square feet of land belonging to her was illegally utilized by the second
BDA.
respondent, BDA.
Formation of 100-feet road.
For formation of a road. Without issuing necessary notifications for acquisition. Full stop. And the petitioner graciously submits that she has no objection for the same. Full stop. However, she contends that subsequent to the said illegal act, subsequent to formation of the road, the committee of BDA,
Alternative site committee.
whatever, the committee of BDA recommended granting of
193
square feet of alternative site
alternative land.
to the petitioner, and that the petitioner is ready and willing to accept the same. Full stop. In spite of the said recommendation passed way back on 12/7/2022, respondent BDA has not taken steps to allot her the site, hence the present writ petition is filed. Full stop. Next para. The counsel for BDA is not in a position to dispute the recommendation dated 12/7/2022 made by the committee of BDA. Next para, Allah continue. Brackets wide annexure F to the writ petition. Full stop. It is unfortunate that BDA has utilized the land of a citizen without following the due process. Full stop. Further, even after taking a decision to allot the land loser a developed site measuring 193 square feet, way back on 12/7/2022, the same has not been allotted in favor of the petitioner, and the petitioner has been constrained to approach this court. Full stop. This is condemnable. Full stop. Hence the following order. Respondent number 2 and 3 are directed to allot 193 square feet of
then they will search for 193 square feet. 193 square feet, then there will not be a site number. Or either 2030.
Why did you pass such an order?
My lords, what happens is, my lords, 700 square feet was acquired, utilized, my lords.
Now, how do you implement this?
My lords, that's why, my lords.
Okay,
Yeah.
BDA is directed to implement the decision taken by its committee dated 12/7/2022 in brackets wide annexure F to the writ petition within a period of 2 months from the date of receipt of certified copy of this order.
In accordance with law, my lords.
Yes. 40 AM.
Lord, I appear for the petition, Lord, seeking writ of mandamus. Lord, petitioner revenue site has been utilized by the respondent for formation of outer ring road, Abdi Road to Mysore Road without acquisition. Lord,
Yes,
he's
Sir,
made several representations.
Lord, page 68, Lord, I have to seek instruction because
The
it is
request of
postponed for.
respondent number 1 and 2 date put. Call on 2 weeks waited.
19,
19th.
41.
Blood, it is a writ of mandamus. This is the third time he is seeking adjournment. Land have been acquired in the year 2010 for formation of widening of the road. Relinquishment deed I have executed in the year 2011, which is at annexure D. And my lord, and in the sketch formed by them for formation of road, they have formed a sketch. And in the sketch also, they have shown my name which is at serial number 25. My lord, they have not paid compensation from past 15 years and still he wants time, my lord. ಮೂರನೇ ಸರಿ ಇದು ಲಾಸ್ಟ್ ಟೈಮ್ ತಾವು ಹೇಳಿದ್ರಿ ನಾವು EC ನಲ್ಲಿ ಇದ್ದೆ ಅವಾಗ ತಾವು ಹೇಳಿದ್ರಿ ಇದೇ ಫೈನಲ್ ಚಾನ್ಸ್ ನಿಮ್ಗೆ ಅಂತ ಹೇಳಿದ್ರಿ ಅವ್ರಿಗೆ ಓರಲ್ ಆಗಿ.
In spite of granting
Repeated adjournments, he is not filing.
repeated adjournments, in spite of granting repeated adjournments at the request of respondent number 3 to 5. He again prays for a time. He again prays for a time. Huh? Full stop. The matter is adjourned to next week on date. 9. At the subject to respondent number 3 to 5 paying a cost of rupees 500 to the petitioner.
My lord, let me be made clear that he will not seek further. It's a mandamus, my lord.
Next
Mandamus
to
go
ICR
adjournment.
Next to 5,000 agata cost. I'm telling you, I'm warning you now itself. No, today I have imposed a cost of 500 on you. Next I will direct you to pay 5,000 rupees cost. Understand that? Yes.
What it to be, Ramesh?
I appear for respondents number 1 and 2, your lordship.
So land has been acquired for a wide.
Yes, are you ready?
Your lordship, the Honorable Supreme Court has granted an order of
I'm
status
asking you,
quo.
are you ready? If you are ready,
Please.
I'll ask them to argue first.
Please, please.
Yes,
please.
go on, Mr. Ramesh.
Lords, the land has been acquired for formation, widening the national highway, my lords.
Ah,
Lords, earlier there was a notification issued by the authorities acquiring a portion of land where the national highway has been formed. Now, my lords, they want to widen the national highway for creating a bypass, my lords, to a state highway. Lords, now there is a dispute in respect of this very same property. Lords, where the dispute is reached up to Supreme Court. My lords. Now there is an order of status quo. Now, my lords, apart from this, the notification.
Status quo with regard to whom?
Lords, regarding the property, my lords, regarding
To be
the
maintained
nature
by
of
whom?
property.
To be maintained by whom?
My lords, for all the parties, my lords. Where, my lords, where?
National
other-
Highway is a party to the proceeding?
Yes, my lords.
No, your lordship, we have filed an intervener application before the Honorable Supreme Court and the matter is posted for hearing on 15th October 2024.
Then
It
we'll
was,
adjourn the matter.
Lords, until
Please,
then,
please.
let them not, my lords, let them not precipitate.
Anyway, there is a.
there is a status quo order already. We are not doing
Yes,
any
the
work, your
request of
lordship.
parties concerned, the request of parties call out of 4 weeks. Yes.
Please.
Sorry.
45. Ramamurthy.
This case, my lord, I have done 5th, my lord. 5th, the AG will.
Attendments.
The request of AJ call on 5th.
59.
Not
46.
final, my lord.
Good.
Because the final
Can be.
will be out of station, any date next week, my lord. Any date next week.
11th, my lord.
11th.
ಅಲ್ಲ 11 ನಮ್ದು ಗಣೇಶ ಪೂಜೆ ಇದೆ 13th or 14th.
13th ಆಗಲ್ಲ 11th ಇಟ್ಕೊಳ್ಳಿ ಇಲ್ಲಾಂದ್ರೆ 5th ಇಟ್ಕೊಳ್ಳಿ ರೆಡಿ ಇದೀವಿ
ಆಯ್ತು ಅವತ್ತು ಎರಡು ಡೇಟ್ ಬಿಟ್ಟು ಬೇರೆ ಡೇಟ್ ಹೇಳಿ
11 12 13th
13th.
ಪ್ಲೀಸ್
Yes, correct. ಆಯ್ತು 1:30 ಆಯ್ತು.
Adjournments.
49, my lord. I am for the petition, I am filing the memo for withdraw the petition.
Yes, 49 dismissed as withdrawn.
Second is from number 50. I mean, convenience in after.
Serial number?
Serial number 14 is second. Settlement is happening, please. 10 days time be granted so that.
Okay, serial number 14, 2 weeks bid date code.
Let's
12/9.
Let's serial number 48, my lord. Pray for time, my lord.
ಯಾಕಪ್ಪ
48, first list.
ಆಯ್ತು 2 weeks. ಮಾಡಲ್ಲ ಬಿಡಿ ನಮ್ಮದು. Serial number 28, you are for? Yes, 2 weeks.
ಏನಲ್ಲ?
Serial number 50, my lords. Kindly grant me short accommodation.
ಮೆನ್ಷನ್ ಮಾಡೋದು ಮಾಡಿ, ನಾವು ರೆಡಿ.
Yes, mention when the matter is taken.
Respondent 5 to 9, my lords. They have.
Mention when the matter is heard, they are objecting to it. I can't grant you time. Wait till 2:30, let's see.
Please, my lord.
Blood serial number 22, my lord, covered by judgment.
ಆಯ್ತು, 2:15 ಹೇಳಿ ತಗೊಂತೀವಿ.